The appeals court, now sitting at Boston, within ample Commonwealth, draw near and give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to the October 3rd, 2024 sitting of the Massachusetts Appeals Court. I am your panel chief today, Justice Henry. My pronouns are she, her, and judge. To my right is Judge Hand, whose pronouns also are she, her, and to my left is Judge Brennan, whose pronouns are he, him. We in the appeals court have 15 minutes of argument per side. For better or for worse, we have no rebuttal. And generally speaking, we're an active bench with a lot of questions. I can assure you we've studied your materials and encourage you to dive into your argument. And with that, we'll call the first case, 2023-P-1158, Commonwealth versus Senon.
Good morning, and may it please the court. Haley Jacobson on behalf of MICHELINE Senon. Although the evidence here raised understandable concerns about the well-being of Ms. Senon's children, the appropriate forum for those concerns was a care and protection proceeding, not a criminal prosecution for reckless endangerment. And that is because the Commonwealth did not have sufficient evidence of two essential elements of the offense: a substantial risk of serious bodily injury and conscious disregard of any such risk. At trial, the prosecutor failed to identify a single potential serious bodily injury that the children here could have suffered, even after the trial judge asked specifically about the bodily injury. On appeal, the Commonwealth identifies two specific potential injuries that the children could have suffered. First, that the children could have become trapped inside an appliance in Ms. Senon's backyard, and second, that the children could have fallen down the stairs to the unfinished basement. But not only do these theories rest on speculation, they also were not presented to the fact finder at trial.
Are we constrained by that, do you think?
Yes, under the
We come up with foodborne illness or bacterial infection or severe malnutrition. You're saying we can't go in that direction because it wasn't part of the trial?
Well, under the Due Process Clause, a conviction cannot be affirmed on the basis of a theory not presented to the fact finder, and that's very clear under the Supreme Court's decision in Dunn versus United States, the First Circuit's decision in Cola versus Reardon, and the SJC has cited both of those cases in numerous cases, including last year in Commonwealth versus Pfeiffer. And I realize that those cases are not cited in my reply brief, and I can provide them to the court in a 16L letter if that would be helpful, but yes, the court cannot.
Are specific manifestations part of the theory, or are they really just adjunct to it, if you will?
I think it depends. If the specific illness that the children could have suffered could have been something that the fact finder here could have inferred based on common sense, then perhaps that is a theory that was presented to the fact finder, but that is not the case here.
They, at a minimum, had to at least have said illness.
Sure, yes, and even that was not done. So I want to go into a little bit more detail about how these two theories that the Commonwealth raises for the first time on appeal.
Could I just ask a couple of factual questions? One is, were there appliances in the backyard that had doors on them that would not open from the inside? Was there evidence of that?
There's evidence that there were appliances in the backyard that had doors on them, but I don't believe that there was any evidence about whether or not those doors would open from the inside.
And was there anything in particular about this stairway to the basement that made it dangerous?
So there was no evidence, in fact.
Record evidence is what I mean.
Yes, absolutely. And there was no record evidence, in fact, about the stairway to the basement at all. So it was not mentioned in the testimony. It was not brought up in.
That it existed, or there wasn't even evidence of that?
No, there was not. I mean, presumably it existed if it's a basement, but there was no evidence about the stairway at all. It was not mentioned in the trial in any way. So not only was it not presented to the fact finder, that theory that the children could have fallen down the stairs, but there was not sufficient evidence to support that theory anyway. Now, as to the appliances, The appliances were mentioned once in the testimony in passing by the neighbor in his description of Ms. Senon's backyard, and the prosecutor did not bring the appliances up at all in closing argument. So again, that was not a theory that was presented to the fact finder in any meaningful way.
Was there documentary evidence from the Board of Health on that issue?
Yes, so the appliances were mentioned and the police officer's concern about the appliances were mentioned in the Board of Health records. But again, that aspect of the Board of Health records was not referenced in closing argument. And in fact, that officer who's referenced in the Board of Health records testified at trial, and he was not asked and he did not testify about anything related to the appliances.
Would it be fair to say that the Commonwealth's argument at trial was that comprehensively all of these component parts were what made the situation what posed the serious risk of harm, that it wasn't necessarily only one discrete part. There were particular concerns, but that it was the totality of those circumstances that were the problem?
I agree that was the Commonwealth, perhaps the Commonwealth's theory at trial, but that is not enough to prove reckless endangerment of a child. This is not, well, first I would say the Commonwealth points to two cases to support the idea that the court looks to the totality of the circumstances, Commonwealth versus Santos and Commonwealth versus Costa, but those are both inadequate supervision theory cases, and I think that the reference to totality of the circumstances there is actually specifically about inadequate supervision theory, and you don't see that totality of the circumstances language in other reckless endangerment cases.
What about, they cite Hendricks, and that's the high-speed chase with the 3-year-old?
Yes.
In the termination was an unjustifiable risk of serious bodily injury, okay? So first, if you can distinguish this case, and secondly, just circling back to my initial question and as a hypothetical, is it your position that the types of illness that this squalor might produce could never be serious bodily injury? Or just because they didn't argue it, they can't now argue it?
So as to your first question about Commonwealth versus Hendricks, I would say the degree of risk present there where the defendant took his 3-year-old child on a high-speed car chase and then on a foot chase from the police, the degree of risk there is simply far greater than the degree of risk here of serious bodily injury. And so Commonwealth versus Hendricks does not support the Commonwealth's case here. On the second question, I would say that my argument is not that the Commonwealth could never prove that unsanitary conditions could cause serious bodily injury. It's certainly plausible that they could, but they did not prove that here because they did not present evidence of what kind of illness or injury the conditions could have caused, the severity of that illness, and whether the effects on the body would constitute a permanent disfigurement, protracted loss or impairment of a limb, organ, or bodily function, or a substantial risk of death. The Commonwealth simply did not provide evidence to support a conclusion that the risk here was substantial, that is, it was a good deal more than a possibility, and more importantly, perhaps, that they did not provide any evidence to support the notion that any potential illness would meet the statutory definition of serious bodily injury.
Is there a case where a conviction is sustained based on squalor?
I'm not aware of any case in the Commonwealth that sustains a conviction on this basis. And I would note that the case that the Commonwealth cites, the Ohio Intermediate Appellate case that the Commonwealth cites in their brief, is distinguishable on a number of grounds from this case, but I think most importantly that the statute there in Ohio requires only a substantial risk to the general health or safety of a child. But here in Massachusetts, we require a substantial risk of serious bodily injury, and that has a specific statutory definition, and there, if it is not inferable based on common sense, which it's not here, there needs to be evidence to support that notion that the risk of injury was of a permanent disfigurement, protracted loss or impairment of a limb, organ, or bodily function, or a substantial risk of death. And I'd like to return briefly to Justice Hand's question about the totality of the circumstances, just to add that the reckless endangerment statute simply doesn't contemplate the type of theory that the Commonwealth presented here about a totality of these circumstances. All of the reckless endangerment cases are about an act or a course of conduct that independently created a substantial risk of serious bodily injury. The Commonwealth cannot add up a number of improbable injuries to create one substantial risk. That's simply not how this statute works, and it never has.
If we can remember that far back, Suppose instead a parent walked their 6-year-old child unmasked into a place that's just, into a COVID ward in the hospital and let them sit there for a couple hours and inhale the air. Is that something that still would require expert testimony with respect to serious bodily injury, or is that more of a common sense, common knowledge situation, do you think?
I think that's a tough line, just because in general, people do have so much more knowledge now about COVID, so perhaps that is something that a layperson could infer based on common sense, the likelihood of contracting COVID from being unmasked in the presence of many people with COVID. But that's simply not what we have here. We have not even identified a specific illness that the children could have contracted from the conditions of the home, let alone the likelihood of contracting that illness, the severity of that illness. None of that is present here. And unless the court has other questions, I would ask the court to reverse the convictions and order entries of not guilty.
Could I ask a question to follow up on your argument that, if I understand correctly, is that there was no evidence that the defendant here was actually aware of the risk of serious bodily harm? If we were to find that there was a risk of serious bodily harm, and I understand that your position is that there isn't one, but if we were to find one, for example, from the conditions versus the appliances in the backyard, is there really a straight-face argument you can make that the defendant was unaware of that?
Yes, I think that it is clear that there was no evidence that Ms. Senon was subjectively aware of the serious risk of harm, and that is what is required for recklessness. It's not simply aware of, general risks. It is under the SJC's decision in Commonwealth versus Hardy, they make clear there that recklessness requires a conscious choice with knowledge of the serious dangers to others involved. And there's no evidence that Ms. Senon was subjectively aware of that the children could have contracted an illness that would constitute serious bodily injury, or even that would constitute serious harm. And so that evidence is completely lacking in this case, and that is another element of the offense. So even if there were evidence to support the notion that there was a substantial risk of serious bodily injury, there is no evidence to support the notion that Ms. Senon was aware of the serious risk of harm.
Would that be true if the serious risk of harm was created by, say, withholding food?
Well, I think the evidence would be lacking here because it's difficult because there simply is no evidence that Ms. Senon was actually withholding food from the children. And certainly there's no evidence that she was withholding food to the extent that it would cause starvation or even close to starvation. And so without evidence of her actions on that matter, it's difficult to say that there was any evidence that she knew her actions would likely lead to starvation or even anything close to starvation.
So in terms of the mother's knowledge of risk, is it correct that the evidence was that the children had been living in these conditions for months?
The evidence was that one of the police officers, I believe, testified that she had been to the home several times in the last year, and that the odors and the clutter and the trash in the backyard were the same. I believe that was the testimony. But again, because the Commonwealth failed to prove that the conditions could create a substantial risk of serious bodily harm at all, there's no basis to infer that being exposed to the conditions for longer would create any greater risk of serious bodily injury. So there has to be.
Go ahead.
There first has to be a risk. There has to be a risk in the first place, a substantial risk of serious bodily injury, which the Commonwealth did not prove.
So even assuming that we concluded that squalor could be enough to support a conviction here, do we need to reverse if we're concerned about the argument that leaving children in the care of someone who does not speak English contributed to this verdict?
Well, I would say that the evidence is not sufficient on any of the theories, so the convictions do need to be reversed on that ground as well as the other grounds.
Thank you.
And unless the court has other questions, again, I would ask the court to reverse the convictions and order entries of not guilty.
Thank you. We'll hear from the Commonwealth, but one other thing I try to say in the introductions is you see we all have these giant iPads up here. It's because we're largely paperless, so all of our materials, your briefs and the record are all on these devices, and that's what we're looking at when we're consulting the iPads.
Good morning, Carolyn Burbine for the Commonwealth. May it please the court. It's our position that when you look at the inferences and the evidence and the inferences in light most favorable to the Commonwealth, we sufficiently proved reckless endangerment of a child. The theory was at the trial a comprehensive view of all of the conditions, the squalor inside the home, the dangers inside and outside the home, and it was just squalid and horrific, and these children.
Can we just, to
Yes.
pick up on Justice Henry's questions, I was going to be a little bit of time. Can we put a hard stop right up front on the argument that leaving your child with a grandparent that doesn't speak English is any evidence of any sort of negligence, neglect?
It's not
anything
that-
that even approaches a
No, it's not that.
forget negligence, forget criminal behavior.
No, right. It's not that the grandmother couldn't speak English. That was predominantly what I meant to argue. What I thought was coming across was that when the parents were not home, or when the mother and her significant other were not home, the children were left with, as the neighbor put it, the oldest, the 10-year-old, in charge, because she could speak English and she had the phone. So they didn't even leave the phone with the grandmother. It was like,
How is that
they
leaving
left.
someone in charge, and how is that different from the circumstances of every immigrant family in the history of this nation?
Well, I think that the problem here is, given the conditions on the property, and the way that the parents were so upset when the children talked to outside people. Like anytime they talked to the neighbor, the mother was screaming at them, Mr. St. Paulin was screaming at them not to talk to the neighbor. So how does that encourage the child to use the phone when there's a problem on the property? And if something's wrong with the child who can speak English and use the phone, and that leaves the 7-year-old and the 7-year-old and the 9-year-old in charge, and the grandmother's intimidated too. She won't even talk to the neighbor if her daughter's home. So everyone's afraid to talk to outsiders. So what happens when the parents aren't home and something happens? That was the point I was trying to make. I'm not trying to say you can't leave a child in the charge of an adult who speaks only French. The point is you're leaving a 10-year-old basically in charge of making the call for help. And how does that work? Especially if she's incapacitated. And everyone is afraid of angering the mother who doesn't want them talking to outsiders. That's really where I was going with that argument. And then we also have.
Do you have a Massachusetts case that says that leaving a child in deplorable conditions is sufficient for conviction of criminal child endangerment?
No, I was not able to find one. And I relied on the Ohio one, not to say that, we have that here. I relied on the Ohio one just to point out it's common sense that this kind of squalor it is unhealthy. But no, I was not able to find.
I understand that may be, but we hear a lot of termination of parental rights cases that involve squalor. And you don't get to use that word that often, but it would be many, many parents who could potentially be convicted.
I understand that, Your Honor, but I think that in this situation with the issue of the supervision, the appliances out back, the defendant's knowledge, the fact, just all of it, the kitchen has rotting food, there's no.
I know, but I mean, I can't speak to every household, but I mean, that's a common problem, particularly for the elderly. And one time we had DCF arguing, that this woman's children should be taken because there was a cat on the counter. So when I hear the Commonwealth arguing a position that would criminalize a large portion of the population, I'm not in any way condoning that people live in squalor or have spoiled food, but, when you get to the margins, it happens.
I understand that, Your Honor, but I think this was an extreme situation where you have a parent who's not encouraging, who's discouraging her children from basically contacting other people if they need help. You have a house that's dangerous inside and out. There's poor lighting. The kitchen is a disgrace. There's no food that's edible for the children. Then when she gets arrested, she locks the fresh food that apparently was just purchased in the car, not knowing when she's coming back, inferably. What are they eating? There's another car with food stored in it. A car is not a refrigerator.
In terms of access to food, was there any evidence about when the defendant's partner was coming home and whether he had access to the cars?
No, Your Honor, but she insisted that the police take her car keys to the car that had the food.
Right, but that
The
doesn't mean
recent
he
food.
didn't have keys.
That's correct. It's silent. The record is silent on that.
You
But
say to Attorney Jacobson's point that we're constrained by the trial prosecutor's failure to identify any serious bodily injury that might have presented.
I don't agree with
Might
that.
is not really the correct term, but.
No, I understand. The Commonwealth's theory was she was proceeding on, look at all of the parts, but when you assess a judge's decision on a motion for a required finding, you're looking at the evidence in light most favorable to the Commonwealth, inferences that can be made. So I don't think the judge was limited by our argument. Was the evidence enough? And circumstantial evidence can be enough. And so I would argue that, we did argue a comprehensive look at all of the parts, and the parts that we gave him were the information about the Board of Health, the information about the lighting in the house, the information about the squalor, the information about the dangers outside, the fact that there were rodents in the yard, the fact that the appliances were dangerous outside, the fact that the chickens were in the basement and kids, common sense, would be attracted to the chickens and their floor is covered with feces from the chickens, and the fact that the child is asking for food.
To go back to that, assuming the chickens were in a chicken coop and you were having the children clean the chicken coop, they could be exposed to the chicken feces, right?
Yes, but this was a floor this would be, you're assuming that they're cleaning the coop, so it's constantly being cleaned, so you don't have a buildup.
Yeah, but you're touching it, and then then you have to trust that the kid is washing their hands, which, they don't always do.
I understand that, Your Honor,
Are there
but
any little footprints down in the basement?
we didn't have evidence of
I'm
that, Your
not
Honor.
joking,
But I think
if
it's
that
common
would change the calculation potentially.
Potentially, but I would argue that it's, again, you can have a common sense assessment, which Hendricks says, and Nababi and Santos. And so common sense, totality of the circumstances, you have what I would assume were pets in the basement, chickens, and you have a police officer who thought it was a dirt floor, and actually it was a concrete poured floor, and the feces and the dust and the dirt is so deep that that's now the floor.
There's no question it was terrible, absolutely terrible. The defendant argues you really identified two particular risks of harm to the children, the getting locked in the appliance and falling down the stairs. I know you're saying there's common sense, but leaving that aside, were those the two particular risks of harm that the Commonwealth identified?
I think, yes, those are the ones identified in my brief, but I also think, the food, if they're actually being given rotten food, which apparently was all that was in the house, then you've got your possible digestive issues. And in Leonard, that was the case with the 16-year-old girl who drank too much alcohol and the social host.
So on that, it seems to me it begs the question, if you're talking about loss or impairment of a bodily function, limb or organ, or substantial risk of death from that sort of a mechanism, wouldn't that require some sort of expert testimony, or is that, you suggesting that's just common sense?
I think it's common sense. In Leonard, they talked about common sense for the intoxication, and the girl was vomiting, and they said that things that affect the digestive system can fall under the substantial risk of serious bodily injury. And I would argue, the spoiled food, they open the refrigerator, it makes the kitchen smell worse. There are maggots in the trash in the kitchen. The child is asking for food, and the mother has just locked the fresh food, apparently, in the car. And so if these kids now, I think it's a reasonable inference, perhaps in some circumstances, maybe they're eating, spoiled food, and then is that really not common sense that spoiled food could give you food poisoning, which could cause very serious problems to your digestive system? I think on all of those risks, the Commonwealth should prevail. Did the court have any further questions?
Thank you
Thank
very
you. I'll
much.
rest on my
We
brief.
understand your positions and the case is submitted. Our next case is 2023-P-1146, Commonwealth versus McCrae.
Good morning. Just as a preliminary issue, dealing with a little bit of vertigo and dizziness, but I'm going to truck through this. I didn't want to leave my sister hanging,
I'm terribly
so I
sorry
might
to
be
hear
a
that.
little slow.
Thank you for trying to soldier through. If you have a problem, let us know.
Thank you, Jen. I would respectfully like to start off with Mr. McCrae's second argument, i.e. that the court erred in instructing on the lesser-included offense of indecent assault and battery. As this court's well aware, the test deciding when an instruction of lesser-included should be given is whether the evidence at trial presents a rational basis for acquitting the defendant of the crime charged. When the evidence introduced would justify conviction, then the lesser-included offense is not warranted under the case law. As you are aware from reading the transcript, the testimony was unequivocal with reference to penetration. The alleged victim in this case, I'm not going to quote her by name, although the case isn't impounded because she was a juvenile at the time. The unequivocal testimony by her is that McCrae touched her where she peed. Now, in light of the fact that we don't actually need penetration as an element per se of the charged crime, I would suggest to the court that the child's testimony in and of itself sufficed for a conviction of the underlying offense. And again, as such,
Just as a preliminary matter, the defendant did not object, correct?
no, the defendant did not object, Judge.
So we're under a substantial risk. What's the standard then?
Yes, yes. I would point out, though, that counsel in and of himself treaded extremely lightly during cross-examination on this issue, and counsel did object with reference to the lesser-included offense.
Can I just go back for a moment and ask you, just so I understand your position? Is it your position that the Commonwealth does not have a right to ask for a lesser-included offense if on some hypothesis the evidence would be sufficient for that offense but not for the offenses charged? Or that
Yes.
it's only, so it's only the defendant has the right to ask for lesser-included?
Please?
Is it, so you're saying it's only the defendant that has the right to ask for a lesser-included offense instruction?
I'm not saying that it's only the defendant that has the right to ask for it. I'm saying that it was not warranted under the facts. If there are sufficient facts to fulfill the elements, then I would suggest to the court that under the case law, the judge erred in giving the lesser-included offense. And in this case...
So, I mean, by definition, right, if there's evidence of the offenses charged, there is evidence of the lesser included. Is that fair? I mean, it has to be, because...
It would have to be,
Right.
yes.
And so then the question for us is whether there was any ambiguity whatsoever that on any hypothesis could have supported the lesser included, but not the rape of a child. Is that right?
With the child's testimony, I would suggest not, Justice Brennan, in light of the fact, again, of the case law that there does not have to be penetration. There has to be merely a touching of the outer lining of the vagina area, and the testimony that he touched her where she peed. That in and of itself, I would suggest to the court, fulfilled the Commonwealth's burden, and as such, the lesser included offense was not warranted. I think this ties into the bad act evidence argument.
Before you move over there, Attorney Giacomo, could I ask this question? What if the jury disbelieved, or what if the jury was not satisfied with the specificity of the victim's testimony about where the touching took place, and ended up believing that a touching happened in a customarily accepted private area of this person's body, but not that it happened on the vulva or labia or vagina? And isn't that a basis for that sort of, in that scenario, would the lesser included have been proper?
I would suggest not, Justice Hand. And again, he touched me where I pee, which would indicate that there was more than a mere placing of a hand.
But that's for the jury to decide. If they didn't decide that.
It is, but again, I think it ties into the first argument of the subsequent bad act evidence. I think when you combine the two of these together.
Counsel, can I ask, just on that bad act evidence, you cite the appellate court decision in Pillay, I'm saying it correctly, right?
Correct.
But the SJC essentially reversed that, and because in the appeals court version, the convictions were vacated, and in the SJC version, they were reinstated, and the SJC took issue with how the appeals court analyzed the bad act evidence, right? So how do we get around that situation?
I think it's still relevant to the case, Justice Brennan. And again, because of the interplay between the two. By admitting the subsequent bad act evidence, which I think we need to start off with the premise that with Mr. McCrae, these are crimes of opportunity. And I would suggest to the court that we've all been around long enough to warrant the belief that most of these types of crimes are opportunistic crimes. And when the court allowed the subsequent bad act evidence, I would suggest to the court that it impugned Mr. McCrae's character, that it was unfairly prejudicial, and that is what caused the jury, in and of itself, to convict on the lesser included offense. Learning that there was a subsequent bad act with the same individual did nothing more than paint a picture of Mr. McCrae as a repeat offender. The bad act evidence really did not fulfill any of the underlying categories in which it would be warranted. Now, the Commonwealth asked under 3 different scenarios, and as the court is aware, the first 2 were rejected. But I think the court has to ask themselves, was there really a need to admit that evidence to show the relationship between the two, when in fact the testimony already was that he was her uncle? Was that information relevant to show passion when, again, I would suggest to you that this is a crime of opportunity? And if the court can't answer in the affirmative to that, then I would suggest that the subsequent bad act evidence should not have come in.
Is it your view that the bad act evidence only did come in for the purpose of establishing the relationship between the defendant and the victim?
I don't think it was warranted under that.
Understanding that, but is that the reason why it came in? Your brief covers a variety of potential other reasons
Yes,
it
but the
could come
judge
in.
did, I did that to exclude them, but the trial judge did state that it was being admitted to show the relationship between. And what more did you have to show with reference to the relationship between, except that they were uncle and niece?
Do you think the judge really meant it in that narrow a manner? As in, what's their familiar relationship? Obviously, that's pretty easy. But more broadly, what is their relationship? Is it a hostile relationship? Is it a relationship that had sexual overtones? Is it just a friendly relationship, paternalistic? I mean, those are all sorts of types of relationships, not just father-daughter, uncle-niece, brother-sister, right? So I think that seems to me from context where the judge was going.
I would respectfully disagree. I think the judge was swayed by the fact that these were two crimes against the same victim, and again, opportunistic crimes. And there was not any what I would term as bad act conduct other than the subsequent act. He didn't see her that often. She had moved out with her mother to a different place for a period of time. So the question, I think, Justice Brennan, is to answer you is what was the Commonwealth trying to establish except that this was an uncle-niece relationship? These weren't acts.
They definitely argue on appeal, and maybe you can tell me whether they argued it below, but that this was to show the defendant's pattern and course of conduct, that he'd find the victim alone and then assault her or attempt to assault her.
But if we operate under that premise, Justice Henry, then he would have admitted the other bad act evidence, the prior bad act evidence against the against the victim's mother, if he meant to show that this was a pattern of conduct on the part.
Why doesn't that just
Mr.
signal to
McCrae.
us that Judge Lang did a careful weighing? And in fact, he said, well, these other three are too collateral, and based on that, I find that the undue prejudice outweighs the probative value. But on this one, for the reasons he said, which were the defendant's feelings and impulses toward the victim, and the relationship between them, that.
But I don't think I don't believe that the testimony as to the relationship between them was bore out to an extent to justify the admittance of the evidence. And I would suggest to the court that this should be viewed through the lens of an opportunistic crime. He spent a great deal of time with her prior to moving out, and we only have 2 incidents. When you take that with the evidence that the Commonwealth tried to submit with reference to the victim's mother when the victim's mother was a young child. Again, these are crimes of opportunity. He happens to catch her in a vulnerable situation, and he allegedly, at least for the second one, takes that opportunity. It's not a situation where he had this juvenile teenage mind and, oh, I got to, I'm in love with her sort of thing that we see prior to the brain development in high school teenagers.
But doesn't it go in the same way that that we held that in Childs, the nature of the relationship speaks to ongoing sexual interest? There are other reasons why that relationship, there are other ways in which the nature of the relationship could encompass the evidence here. Why isn't it reasonable for the judge to have?
But those were all summarily dismissed by the judge. He specifically said he was letting it in under the premise that we are arguing. And I would suggest to the court, when he summarily dismissed any of the other reasons, that they should not be weighed by the court. The error is in fact based on what reason he stated he was admitting it. And I see I'm over, so if the court doesn't have any other questions, I just rest on the brief, and I thank you for your time.
Thank you. I hope you feel better.
Good morning. May it please the court. Erin Knight on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. I'll start off where my brother left off with the attempted secondary assault testimony. The judge found that this testimony was relevant and the unfair prejudice didn't outweigh that relevance based on the fact not only of the relationships, but that the defendant's feelings, emotions, and impulses regarding this particular alleged victim. And here I would actually point to the fact of the other three instances the Commonwealth tried to get in, and what Justice Brennan said about contemporaneousness, or contemporaneous, that word, is that this is different because it is closer in time, though it is a few years later. It's still with this victim. This victim is, yes, it is a crime of opportunity, as we often see in these situations, but the family is sleeping. He knows that the family is sleeping. He knows that no one is quickly coming to her aid. And I would also point out that this evidence was used by trial counsel in closing argument to, in fact, argue that the victim cannot be found to be credible and is lying because the victim stated that during this attempted second assault, she screamed for her grandmother and nobody heard her, even though her grandmother was across the way. So I would state that the prosecutor, in using this evidence, in using this particular assault or alleged assault to cast doubt on the first assault and also the relationship and the delayed disclosure. That's another huge part here. He's using all of these instances and that delayed disclosure to say she's just simply not credible.
You're not suggesting, I'm sorry, Justice Henry. You're not suggesting that we should hold it against the trial lawyer who's stuck with what he may perceive to be a bad ruling to try and flip it and shine it as best he can for his final argument.
Absolutely not. But if anything, I think, it did actually help him to bolster that she shouldn't be believed because no one came to her aid. Well, she was screaming. I think also it's enlightening that there was no limiting instruction requested. And so it might have been a tactical decision, but we don't know as there was no motion for new trial below regarding any of those tactical decisions. I will also point out the judge gave in his final, gave a strong limiting instruction regarding this evidence. That's actually the transcript number 3, 23, and 24. So the jury were instructed on exactly how they were to use this evidence. And if anything here, this was actually not a crime that was committed, this secondary attempt. There was nothing substantially prejudicial about it where there was no underlying actual act that could be seen as being a crime in and of itself. It's more of the situation. I'm sorry?
Not an attempt at a crime?
It is an attempt at a crime, but it was not charged as such. So I think the underlying actual factual situation definitely went more towards the defendant's impulses and his impulse control regarding this victim and his situational opportunity that he had.
So is impulse control an exception that allows this kind of evidence in?
I would argue that it is. Under Centeno, you have the pattern and course of conduct, intent, and the relationship between the defendant and the complainant. And I would say that the intent, the impulse of what he is trying to do, the behaviors towards the victim, it shows his sexual interest in the victim. Those are all relevant to supporting her story on the stand. And I would also state that here, with the situation that they had, no one came to her aid, and he knew that, right? The rest of the family were sleeping and weren't going to be quick to react, and I think that is important here, that he found these situations for a certain reason. And if I may turn to the secondary issue of the lesser included, again, it is a substantial risk of a miscarriage of justice standard, but I would also point out that actually at trial counsel agreed that the lesser included offense should be given. He actually even told the judge that it is under any view of the evidence. The word is any view of the evidence. And here, the victim did testify that he touched her where she peed, but I think if you take that can be ambiguity in and of itself. But if you take that and actually combine it with the trial testimony of Dr. Newton, that were young girls, the victim was 8 at the time of this assault, young girls may not know what actual penetration feels like. She quoted, "Going in between the labia feels like penetration to a young girl. Touching the hymen is also very painful and can feel something went inside." And the continuation of that testimony basically almost casts light on whether the 8-year-old victim, yes, she was 22 at the time of trial, but she was 8 at the time of the assault, would have actually known penetration, would have actually known what the pain or the feeling was she was having. And so I think under any view of the evidence, there is an ambiguity here that could be taken. It is certainly outside the bounds of, say, Ortiz, where the victim was explicit that there was anal penetration. This was, she didn't say the words. The prosecutor's trying to get her to say the words, and the words weren't there. And so under any view of the evidence, there was certainly, the judge found an ambiguity, and the lesser included was proper.
What do you do with the yes response to, I'm going to quote this wrong, but there was a question about whether some part of the defendant's body went inside your body, and the answer was yes, fingers went inside. It was an agreement, not a statement. What do you do with that?
Correct. Well, the question can color the evidence, of course. Questions are not evidence, but of course the context is there. Her answer being yes is evidence to that question. But at the same time, I think, she couched it then after that as it's where I pee. She also, it's a credibility determination for the jury. And so here where the credibility, it was a he said, she said case, as we often find in these cases, with the victim being so young, it being so long ago, there being a delayed disclosure, I think that where the judge properly found that there was ambiguity, that's the trial transcript number 2 at page 88, I think even though she said the fingers went inside of my body, again with Dr. Newton's testimony, she might not know what inside necessarily meant or felt like.
So is it the Commonwealth's position that if the jury could have determined that the defendant touched this victim's pubic area, but not to the degree required for the legal definition of penetration, then the lesser included would have been appropriate? That made the lesser included appropriate?
Yes, I would agree with that. I would state that I think that's explicitly apparent with Dr. Newton's testimony of how young girls may kind of believe or may feel things. And I think that, part of the testimony was also his hand was in my underwear. So it was, there was testimony, but it wasn't necessarily explicit. It was inside of my vagina or touched my, the jury were free to credit what they felt. And in light of Dr. Newton's testimony, I think that was absolutely proper here. And if the court has no further questions, the Commonwealth would rest on its brief.
Thank you very much.
Thank you.
We'll hear the third case of the morning, and then we will take a break. That case is 2023-P-10 9-2 Commonwealth versus Broner. And I'll speak for myself and say I do have a number of questions.
Good morning, and may it please the court, Paul Rudolph on behalf of Michael Broner. If a trial is supposed to be a journey towards the truth, this one veered badly off course, and there were really two co-pilots, Mr. Broner's lawyer and the trial prosecutor. Specifically, Mr. Broner's lawyer, in a case that really turned on the question of which of these two men initiated a physical confrontation that ended with this fatal discharge of a single bullet. His lawyer failed to introduce potent and really indisputable evidence that Kevin Blanton was angry with and threatening towards Mr. Broner that very night. And the prosecutor took advantage of this failure, particularly in her badly improper closing argument that the trial judge himself called disturbing, when she painted this false picture of, on the one hand, a nearly angelic, peaceful Kevin Blanton, and on the other hand, an angry, violent Michael Broner who was bent on attacking Kevin Blanton that night. And because of this prosecutorial misconduct and ineffective assistance of counsel, both alone and in combination, this jury did not get the truth, and Michael Broner did not get a fair trial. Now, I've raised a number of issues in my brief. I'm happy to answer questions on any of the issues. I would say that the issue that most clearly merits reversal is the prosecutor's closing argument, and so I'd like to begin by addressing that.
Before we get to that, do you agree that the jury concluded that the defendant brought the gun?
It does seem like the jury reached that conclusion, yes. In terms of the closing argument, this is a really unique situation because we had a trial judge who essentially anticipated that the trial prosecutor would cross the line, perhaps because of arguments they had had already during this trial. And he specifically told her that she could not make an argument about Mr. Broner choosing to come late at night while Mr. Blanton was alone and vulnerable, because that was sort of part of his plan.
So counsel, I mean, I agree. As somebody who was never characterized as a shrinking violet, I was shocked by some of the behavior that I read in this transcript. I will give you that. But the Commonwealth is saying still that there were sufficient curative instructions here and that the defendant didn't object to everything that was improper, and so we should affirm.
Well, the defendant actually did object to almost all of the improper closing arguments. Not only did the defendant objected during the closing, after the closing, moved for a mistrial twice. So on the specific argument that they debated before closing, the defense unquestionably objected, and along with all of the other arguments about him supposedly loading a firearm before he went over there.
Would you agree that, if not all, virtually all of the improper argument went toward deliberate premeditation?
I would agree that they went towards that and other issues. So the prosecutor...
What are the, because at least as to that issue, it seems like the jury took care of it by rejecting the theory that...
Correct, but all of these improper arguments that Mr. Broner was angry while he was back in Springfield, no evidence of that, that he loaded this gun in Springfield before going over the house, no evidence of that, that he was planning...
But that's all premeditation, isn't it?
It could be premeditation, but it also goes to other issues that were decided against Mr. Broner in this case.
Can you identify those?
Yes.
Mr. Rudolph, please?
Those arguments go to who initiated the physical confrontation. They go to whether he was defending himself or not. They go to whether he brought the gun or not, because a jury could have concluded that...
Can I ask you on that one, though?
Yes.
And the closings came after the testimony, and he testified he didn't bring the gun.
Correct.
Right? So you're saying they clearly rejected his testimony, and the closing then improperly brought the jury to the point? Is that what it is, that they seem to accept that he did in fact bring the gun?
They did accept that he brought the gun, and I think that in this case, the jury very well could have concluded that he was angry, before he left the house, because that's what the prosecutor argued without evidence, that he was planning on or thinking about a fight or an attack, but not necessarily that he was intending to kill Mr. Blanton, right? That's what they rejected, that he went there with an intent to kill him. But that doesn't mean they rejected that he went there with a hostile attitude, that he went there with some thought about maybe attacking him if the opportunity arose, and that maybe he brought a gun in case he needed to use it. And all of those conclusions that the jury could have drawn based on this story that the prosecutor just spun out of whole cloth that was not based on evidence, as the judge himself agreed and found, all of those conclusions the jury could have drawn undermined self-defense, undermined voluntary manslaughter, and could have supported third-pronged malice, for example, even if they rejected intent to kill, which was necessary for deliberate premeditation. So he still was prejudiced by these. And to answer your initial question, I think it was yours, Justice Henry, there was no curative instruction. The judge said he was going to give a curative instruction, and then he didn't.
He just gave the usual instruction, right?
He gave the usual instruction, and when he was talking about inferences, he said the parties argued certain inferences, but essentially it's up to you to decide what inferences are based on the evidence. He didn't do what a curative instruction should do, which is to say this argument was improper by this lawyer. You should disregard it. Never happened. And in fact, he admitted at the Rule 25b-2 hearing that his instructions, I think, upon reflection, might not have actually been specific enough. And so we have this unique situation where the prosecutor made a number of improper arguments not based on evidence, objections, motions for mistrial, no curative instructions, and they did go to central disputed issues that seemingly were just decided against Mr. Broner. So it's hard to conceive of a case where the prosecutor crossing the line, in this case, like in defiance of the trial judge, where that doesn't merit reversal.
So I want to change gears and go to the text messages. Did the defendant try to get a ruling from the judge about the text messages and what would or wouldn't be admissible?
The Commonwealth actually sought to introduce the whole text chain that included Ms. Calandris's, back and forth that went on and on between her and Mr. Blanton. And the defense actually objected to any of that coming in. The judge said her text messages to Mr. Blanton are just not relevant because they reflect her state of mind, not Mr. Broner. So I'm not letting that in. But what Mr. Bronner's lawyer, I think, just really failed to recognize, and I don't know why, is that Mr. Blanton's text messages to Ms. Calandris about Mr. Broner was really the only evidence that he had, and it was very powerful evidence that Blanton was angry with Broner and would have had a motive and a disposition to initiate this physical confrontation.
Is that covered anyway because they showed up at 1 o'clock in the morning to retrieve the child?
That doesn't show anything about Mr. Blanton's anger towards Mr. Broner.
Almost everyone would be pretty angry about that.
Mr. Broner never even went to the house. He was just sitting in the car, so he would have had no reason to be angry at Mr. Broner. In those text messages, he's saying he's angry at him for essentially disrespecting his daughter. He's referring to some earlier dispute that Mr. Broner had with his
Right, that was another question I had, actually. So did the defendant fail to present any evidence that the daughter had maybe, worked the father up about this issue, the victim up about this issue, as kids can wind up, I guess is what I'm looking for. Kids can really wind up their parents. Not speaking from experience, of course. Did no evidence of that come in?
Not only did no evidence that came in, what came in was that Mr. Blanton was not upset at all. This is what the prosecutor literally said in closing. He wasn't angry that night. He wasn't angry after getting these text messages from Ms. Calandras. He was home. He was playing with his children. He was having dinner with them. This is why I'm saying she painted this false picture of like this peaceful, angelic man who wasn't upset at all with anybody. And so the jury had this totally false impression about his state of mind, especially as it related to Mr. Broner. And so as the trial judge pointed out during motions in limine, like, as he said, one of these two men, or maybe both of them, must have had some reason for this sort of sudden assault to occur. And unfortunately, the jury only heard this false version from the prosecutor about Mr. Broner being angry back in Springfield and plotting this attack, and Mr. Blanton being this, peaceful, fatherly figure, and that just wasn't the truth.
Counsel, with respect to the text specifically, this may be a small point, but with the admission of the texts that indicated that the victim was upset about what the defendant had allegedly said to the victim's daughter about the victim, have then provided the Commonwealth with the opportunity to introduce evidence that suggested that the defendant was known to the victim to be a potential hammer. If you keep this up, according to the mother, if you keep up saying to the victim, if you don't hand over my daughter, I'm bringing mittens over to, be my enforcer, so to speak. Is that not a reasoned basis to keep that out?
That's not at all what she said in those text messages. I know that's what the Commonwealth said in their brief.
No, that's why I was reading it, but that's my interpretation of it, may be wrong.
Right,
So
no, and I tried to address this in my reply brief. She said, I'm going to get a ride over there with him. That's all she says. He was going to drive over there with her. She didn't even intimate that he was coming as some muscle or threat or anything like that. She did say, you'll never see your child again, but that followed immediately, that was immediately after her statement, I'm going to call the police and tell them that you're not returning my daughter to me. It was like a custody argument that she was making to him. So it's not true. I think it's really a false picture to paint that she was threatening to bring him over there as some sort of enforcer. And I encourage you to read the full text stream because they really don't think they bear out that interpretation. But
understanding that it's not the focus of your argument, can you just take a moment on the ineffective assistance for not requesting the involuntary manslaughter?
Yes.
Because again, the trial counsel had a strategy. You might not like the strategy, but it seemed to be, at least according to him, consistent with what his client was telling him. And it just strikes me as I read it that, number one, throwing every possible scenario out there is not great defense work, and I think the trial lawyer said that in his 30-plus years. That's just not the way to go about trying a case. And then secondly, though, if you're looking at involuntary manslaughter, I don't see how not bringing the gun is consistent with the involuntary manslaughter theory. I'm not seeing it, because most of these are shot it to scare him and oops, he moved, or brought the gun. They're all brought the gun and then something bad happened.
right, so first of all, the trial lawyer acknowledged that he didn't consider this, right? So there was no strategy behind this. This is his sort of post hoc rumination about, which he decided to put into the affidavit about, well, had I thought about it, here, I wouldn't have done it for these reasons.
His strategy, he said, was not guilty. Self-defense, accident, not
Correct.
guilty. There's my strategy.
That's right. And yet, even despite that, in his closing argument, he actually says, well, there's also this other theory of voluntary manslaughter that you can sort of consider. So even his own post hoc claim that he wouldn't have asked for that is actually undermined by his own argument in this case. Like, he actually recognized explicitly to the jury that there was a possibility of a manslaughter verdict.
But those theories under the voluntary manslaughter, whether it's excessive force in self-defense or in the heat of passion, whatever, there wasn't exactly how he phrased it, but those are at least consistent with his client's testimony that I didn't have a gun, this guy came at me, I went out, he had the gun. It just seems to me that the Doing it the other way really would have undercut his defense.
I don't actually think the voluntary manslaughter is consistent with his client's testimony, because voluntary manslaughter involves an intentional killing, right? And he was saying, no, his client's testimony was, I didn't have a gun, he had a gun, I was simply trying to push him away and the gun discharged, right? So that was not consistent with his client's testimony. In a way, and the involuntary manslaughter theory, which I think there's a decent chance the jury might have ended up at if they'd had that opportunity, is predicated on, well, if the jury had rejected the idea that his client didn't bring the gun, but he did step out of the car with a loaded gun because this angry guy was coming to confront him to perhaps scare him away, and then things got physical and the gun unintentionally went off, which is actually consistent. The unintentional discharge was consistent with his testimony. So there's a way in which that is just as consistent with his testimony as the voluntary manslaughter theory. And, this is a situation where the defense strategy was not all or nothing. The defense strategy was to ask for a path to manslaughter, and he just didn't recognize that there was an alternative path to manslaughter that was in fact supported by the evidence. And so that's why it wasn't a strategic decision. He just didn't think about it. There was a factual basis for it. And it wasn't any more inconsistent with his theory than voluntary manslaughter. And he didn't have to argue it. You could have just had the instruction. We do that all the time. We argue a theory but ask for a lesser included instruction in case the jury rejects some piece of our theory. So I see that I'm over time. I'm happy to answer further questions.
I do have some questions. So sticking with this issue for a moment, the Commonwealth says that the only scenario that you described that might support the involuntary manslaughter would be basically the defendant brought the gun, the deceased angrily confronted him, the defendant got out of the car, and that led to a struggle and an inadvertent discharge. Are they right? That's the only scenario?
That is the scenario that I'm suggesting supports involuntary manslaughter. Right. They're arguing that doesn't support involuntary manslaughter, and I just disagree with them. And I've cited multiple cases in which a person sort of introduces a loaded gun into a heated conflict that ends up not by the intention of that person killing somebody. There's case law to that, and the Commonwealth cites no case law that suggests this is not a basis for involuntary manslaughter.
Right, but they do argue that even if you're right, we'd only grant a new trial in an extraordinary situation where we were uncertain whether the defendant's guilt was fairly adjudicated. Do you agree with that? Citing the Chase case.
No, I think that if there was a factual basis on which an instruction could have been given, and the trial lawyer did not have a strategic reason for not asking for that, then there was ineffective assistance of counsel that warrants relief for my client. And I think that the relief doesn't necessarily have to be a new trial. I think in these situations, the Commonwealth actually has the option of accepting a reduction to involuntary manslaughter or retrying the case. For other reasons, I think he's entitled to a new trial that I've already argued and will leave to my brief.
On the voluntary manslaughter, the Commonwealth argues that basically the jury was just entitled to conclude that the defendant and the victim argued after the victim said, "Come get your girl," and that the defendant then just shot him in the chest. What do you say to that?
This was a case where the only evidence of what really happened between these two people at the side of the car, where clearly the victim came out of the house, crossed the sidewalk in this sort of snowstorm, where my client was sitting in the car, the only evidence of what happened between them was the testimony of Michael Broner. And it was enough to raise, it was enough evidence where all the parties and the judge agreed there was a basis for a voluntary manslaughter instruction, and the burden of proof then shifts to the Commonwealth to disprove mitigation. And my argument is there was no proof that they failed to disprove mitigation. There just was no evidence that it was anything other than what Mr. Broner said. The jury can disbelieve Mr. Broner, but but that's not substitute for affirmative proof that this was, that there was an absence of all three theories of mitigation.
Just briefly, because we're very far over time, what pages in the record are you wanting to look at, having us look at the phone call? Because I don't quite understand. You're saying if I look at page 391 in the record, there's this thing about entry 835 shows the last time at least that he opened the contact, but does his phone somehow work differently than other people's phones, so it doesn't show you every call that night? I didn't understand that.
This is complicated, but essentially...
At least one of us is not following it, so...
No, and I know it's very complicated to unwind, but basically the dispute was Michael Brawner's testimony. I was just sitting in my car having this conversation with this woman named Deja, and the Commonwealth impeached him by putting on a trooper who said, well, I downloaded his phone, and the only two phone calls that were made at that time essentially were to this other person who had texted him, it's Mike. The defense that cross-examined that trooper and said, but there were 12 deleted phone calls. And the trooper said, yes, but those were all recovered. The defense then came back and said, yeah, but the report shows that deleted and recovered phone calls are in red, and there's only 2 of those during this time period. Therefore,
so what pages should I be looking at that point? Because I'm not seeing red.
And that could be a problem with the brief, with the reproduction. So I believe that,
And this is also very long. Oh, no, there is red
I think it's
here.
really in the testimony, to be honest, because actually it's in the, it was an exhibit that I introduced at the motion for new trial, or that I submitted in support of the motion for new trial. The report itself was not introduced as an exhibit at the trial.
The full report,
The full,
5,000
actually
page.
none of it, nor was the shorter report. But there was testimony about this, and the trooper admitted, yes, there are only 2 calls in red, but the rest I believe, are in there, something to that effect. And then the prosecutor went on to argue improperly in closing, they're all in there, the whole report. The report's over 5,000 pages, it's in there. That report wasn't in evidence.
That was to the best of my knowledge. The trooper's answer was to the best of my
Trooper said, to
knowledge.
the best of my knowledge, correct. So I apologize, Justice Henry, that I'm not helping you more with that, with that question.
Thank you very much.
Thank you.
We'll hear from the Commonwealth.
Thank you. May it please the Court, David Shepard Brick on behalf of the Commonwealth. So the trooper explained, a new trooper explained in the motion for new trial that there are no missing calls, that it was an older version of Celebrate that was simply not parsing the data correctly, and that there were no missing calls, and that this last time contacted entry in the full report of this person named Deja was simply showed that the person who had the phone accessed that contact at 2:37 a.m., but there was no actual phone call. There were no phone calls to that number during the entire time period of the extraction, which I believe was about a day.
Right, so the defense counsel says, were you on the phone? So clearly the defense counsel knew the defendant was going to testify he was on the phone.
Yep.
And it's not until the prosecutor says what was the woman's name that we find out it was Deja, right? So, and your theory is that the defense attorney was surprised when he didn't say Mike, when he said a female friend. But there were still several days of trial left, and there's no indication that the defense counsel tried to do anything to figure out who was on the phone.
There isn't, because there wasn't anyone on the phone but Mike. And that's what the records show. And he said in his affidavit, If the defendant had told me who this was, I would have gone looking for it, but the only call at that time was Mike.
Right, but the defense counsel is not supposed to elicit testimony he thinks is a lie, and he does ask him directly. He doesn't let the defendant just introduce the concept that he was on the phone. He specifically asks him, were you on the phone?
Right. Well, he asked him, were you on the phone? Because there was a phone call at that time period to this number, Mike. So I think he expected him to say that I was on the phone with Mike.
Okay. So you think that he was on the phone with Mike, and that...
That's the only, well, I don't know, the timeline doesn't exactly match up because those calls were before 1 and the 911 call is at 1:10. So that's the closest calls to the actual incident are the ones to Mike.
Before 1 a.m.?
Before 1 a.m.
All right, so starting at the top of the order with the voluntary manslaughter, the defendant is arguing, well, let me back up. Is it fair to say the jury rejected the premeditation theory?
Yes, they did.
Okay, and what evidence did the Commonwealth present about whether the defendant was sitting in the car or was out of the car at the time that the victim came out?
So there was essentially no evidence other than the defendant's testimony as to whether he was inside the car, no direct evidence. The Commonwealth pointed to the fact that the victim, when he walked out the door, his girlfriend testified that he walked out the door and 2 seconds later he said, "Come get your girl." So that was the Commonwealth's argument, that he wasn't in the car because he would have had to walk down the driveway, down the path, and get to the car if the defendant was in fact sitting in the car. So that was the circumstantial evidence that he was in fact outside the car. There's also the portion of the defendant's testimony where he said he was standing outside of the car and then later said, "No, I didn't get out of the car." The trial judge said, well, that could have been a slip of the tongue. I think the Commonwealth's argument was he slipped up and told the truth. So I think that...
So, but what he's trying to say, though, what he's arguing, though, is there's just an absence of evidence about what happened other than come get the girl. Like, at that point, then, we don't know because nobody was there other than the defendant, and let's just put him to the side for the minute because he has some self-interest here, that there's no evidence about who initiated any conflict.
There's no...
How do you rule out heat of passion or the other theories?
Because the defendant has no injuries.
There's no injuries.
No
Okay.
injuries. Documented, photographs admitted, showing his hands, his arms, no injuries. The victim has a scuff mark on his neck and the bullet wound. So there's really no evidence of any type of hand-to-hand struggle beforehand. The only evidence is afterwards when everybody comes out and the defendant is on top of the victim, according to the victim's excited utterance, trying to shoot him a second time. So I think you have the victim's excited utterance, certainly that he shot him once.
So he shot me, he's got a gun, he is trying to shoot me again. What are you saying is significant about those statements?
I'm saying that it contributes to the overall picture of, that there wasn't a type of struggle beforehand. You can argue that, well, he just didn't mention that we fought, but I think the fact that he said he shot me, he's got a gun, and that he's pinned to the ground with the defendant attempting to shoot him a second time, that really shows that, again, there's just...
So how do we know that the victim didn't run at him with that giant flashlight?
Well, I think because the only evidence that he had the flashlight in his hands when he came at the defendant was the defendant's testimony. There was a bloody flashlight recovered, but it wasn't recovered there. So
I thought that the defendant, that the victim's partner testified he got something off of the top of the refrigerator, or?
That he took something out with him, that he had the flashlight, but there's nothing that says that he ran at the defendant with him,
Right, but that's the issue. There's nothing that says he did or he didn't. We don't know, and you have a burden to exclude too much force and heat of passion, right?
If it's properly raised, I think that if you discount the defendant's testimony, that there was the Commonwealth doesn't have
Setting
to.
his testimony aside, you have to disprove certain things, and I'm trying to figure out how you did that.
The way you simply disprove that is if you discount the defendant's, I know you said that you discount the defendant's testimony, but there are a number of cases where there is no direct evidence of what happened. I would point to the Ranchi case, 491 Mass 284, where the SJC said the jury could have adopted the Commonwealth's argument that the defendant killed with premeditation. The only evidence was multiple stab wounds.
The only evidence was what?
Multiple stab wounds. There was no eyewitness to the incident. There were simply multiple stab wounds. And here you have at least the attempt of multiple gunshots.
So are you arguing that under Ranchi, you don't have to demonstrate to us that the Commonwealth disproved mitigation? All you have to show at this stage is that there is sufficient evidence from which the jury could have come to the conclusion that it did?
Right, that the Commonwealth's burden, I don't have to disprove mitigation, I have to show that a reasonable jury could have discounted any evidence of mitigation. And I think that's the way you have to look at it, is if there's evidence of mitigation, it simply drops away in the sufficiency analysis. And then you're left with one gunshot and another attempted gunshot.
Yeah, so on the attempted gunshot, do you have to have someone like pull the trigger and have the gun not go off? Otherwise what is an attempted gunshot other than that?
So, again, the testimony was struck, but the girlfriend testified that she saw the defendant pointing the gun at the victim with his finger on the trigger. And she made a couple of demonstrations after that testimony was struck. But there was also the testimony of the ballistician that the gun would fire properly, but there was something wrong with the safety. Not that the safety would prevent the gun from firing the first shot, but that after the gun cycled once, the safety could accidentally engage and prevent a second shot. So that was the ballistician's testimony. So, and between the observation of the victim basically saying, he's trying to shoot me again, which is him saying, he just shot me, he's doing the same thing with his hand that I just saw him do.
So on the involuntary manslaughter, is it fair to say that the defendant argued for full acquittal on the theory that the gun accidentally went off?
I mean, that was, his argument was that he didn't bring the gun and that they were struggling over the gun. That was his testimony, that they were struggling over the gun and he was holding on to it and that it just went off.
Right, so defendant on appeal is arguing that voluntary manslaughter is inconsistent with that factual argument. Is that right?
I mean, I don't know that it's inconsistent if, it's inconsistent with his testimony that he wasn't holding the gun, but it's certainly, for excessive force in self-defense, even if he didn't bring the gun, if he got a hold of the gun and then used it, I think then you have an excessive force in self-defense case. That wasn't really part of the testimony, but that was, I guess, an argument you could make for that.
So the defendant argues on this point, though, that the motion judge ruled, and I think he's quoting, but this is my best belief, as the trooper said, that the evidence at trial was sufficient to support the jury's rejection of voluntary manslaughter in favor of second-degree murder, so there was no prejudice to the failure to request the involuntary manslaughter instruction. Is that correct?
I think it is, I think the fact that the jury was presented with a lesser included and rejected it is some evidence that they would have rejected another lesser included, and I think you see that in the case law. I also point out that Tavares, the big case that this is supposedly based on, was not an error. The SJC said, in the absence of a request, it was an error for the judge not to give it, and it wasn't the reason for a reversal in Tavares. It informed another error, which was an instructional error, which had to do with the co-venturer having to be convicted of the same. There was an error in the joint venture instruction in Tavares.
So I may agree with you that trial strategy-wise, arguing for or even asking for both voluntary or involuntary manslaughter might not have been the best way to go. But why was he not, on at least the facts that the jury heard, entitled to an involuntary manslaughter if that's what he wanted, if that's where he wanted to go with it?
Because introducing a loaded gun into a physical confrontation presents a plain and strong likelihood of death. It was loaded, and we know it was loaded because it went off, and
So you're saying with his testimony that he introduced the gun, there is no theory under which...
If he introduced the gun, then it has to be a plain and strong likelihood of death, because the other cases where the defendant introduced the gun, but it wasn't, was found to be potentially involuntary manslaughter, the defendant didn't fire the fatal shot. If he introduced the gun and...
When he shot in the air? Wasn't there one where they shot the gun in the air?
So there's one where he shot...
The one where the co-defendant took the gun, I got you.
Right.
That's different. But the one, and I don't remember the name of it, forgive me, but there was one, I believe, where the defendant had the gun, introduced it, shot it in the air, and the question was, did the bullet land on the, or was it?
Yeah, I'm trying to remember. I know there was one where there was a nightclub shooting where he was shooting into the ceiling, and then he turned and shot, and the court said under that theory,
Right.
you're no-go, but we...
So if he brought the gun and he aimed over here to scare him, and then the guy fell down and into the bullet, you're saying what's that?
I mean, firing a gun when you know a person is around is in front of you. You know, you have the Horn case where
Right.
he couldn't have, it was possible that he didn't know there was anyone in the room, so that's where, but when you discharge a firearm, and the jury was given an accident instruction, they were said, the judge told them, accident negates the three prongs of malice. So they found that, at the very least, he intentionally at least put his finger on the trigger, because 5.5 pounds of pressure was required to discharge this.
So you're saying, just so I understand it, and tell me if I'm putting the wrong words in your mouth, that where the instruction says wanton or reckless conduct and usually involves an affirmative act, here the affirmative act must have been introducing the gun.
Introducing the gun and having your finger on the trigger.
And shooting it, okay. I got you.
And again, it was a single action only pistol. It was, which the trooper explained, means that the hammer is already cocked when you load a bullet, so you would have seen that from the outside of the gun. And again, he said the trigger pull was 5.5 pounds, which is not insignificant. It's not a hair trigger.
So on the text messages, I do agree that the Commonwealth wanted to introduce them and the defendant objected?
That is correct. And the judge, in fact, ruled that he said, I can find it was on the January 28th transcript at 27 to 28, the Commonwealth saying, well, we just want to introduce this small amount. And the trial judge essentially says, if I introduce some of it, I have to introduce more of it, otherwise it's misleading. So the reverse, if the defendant says, oh, I just want this one text message, the judge has already made clear that he's letting in more to make it fair, because otherwise introduce just one or two is misleading. You have to give context to this, to the entire discussion.
Right, but then but the prosecution knows there's this entire discussion and knows that that the victim is, well, certainly using slurs towards the defendant.
Yep.
But even with that knowledge, then says that the victim was a peaceful, totally relaxed guy that day. Is that okay?
It is, because the supposedly angry text messages come earlier in the evening. I don't think that.
Well, there's one around like 7, but then there's another one that's around 10:50, and then 2 hours passes, yeah.
Right. I think that's the argument, is that he had 2 hours to cool off. And there was also the testimony.
Sometimes it matters who the proponent of evidence is. If the defendant had proposed to introduce just the victim's text, is there a reason why it would have been inadmissible to show something like state of mind?
I mean, so I think it's more difficult for him to introduce them than it would be for the Commonwealth, because the, Colondres is arguably, I would say there was preponderance of the evidence that she was a joint venture to an illegal, not necessarily the charged offense, but certainly an illegal enterprise to go over there and cause some trouble. So I think the Commonwealth gets her statements in, and then the victims come in to give context. I don't know that the victims, when there's without direct evidence that they were communicated to the defendant, or at least the inference that they were communicated to the defendant, I think it's harder for him to get those in.
Right. On the daughter telling the victim that the defendant had disrespected her, so no evidence of that came in. Is that right?
She didn't, they didn't get into that, is my recollection, is that it wasn't brought up, the Commonwealth didn't introduce it, and the defendant didn't want it to be. The defense counsel was very clear that his strategy was, I don't want it to be about anything else. I want it to be what happened right then and there.
And when, in the changing topics again, because there are many topics in this case, with whether the victim came at the defendant with a flashlight, defense counsel did not introduce that the daughter affirmatively said the ride was completely silent and the defendant didn't say anything. The defendant didn't bring that in, right?
He didn't introduce that specific portion of her
Yeah, so why
statement.
isn't that powerful? Because the judge said that wasn't powerful, but it completely contradicts the flashlight comment.
I mean, he impeached her on a lot of different things. He impeached the fact that she didn't mention that in her two statements. So the fact that he didn't introduce one prior statement that impeached her on the exact same point, that's one of those where reasonable minds can differ on what's the most effective way to do it, and I don't think it was manifestly unreasonable that he chose one over the other.
Let's end where the defendant started with the closing argument, where the judge kept telling the prosecutor not to do certain things, and the prosecutor disregarded that. Well, let's just start with, do you think that anything that the prosecutor did in closing was improper?
So there were certain arguments that I think crossed the line. I don't think that the arguments relating to premeditation, which the jury rejected anyway, crossed the line. The judge said, well, just because he brought a gun, well, I guess you can argue. And in fact, he's sort of musing. He says, well, I guess that sort of supports premeditation. It in fact does. Bringing a loaded firearm supports an inference of premeditation, so that argument was proper. The ballistician said that when you load the gun, the hammer is cocked. So to suggest that he loaded the firearm, he loaded it at some point.
At some point.
And he knew it was loaded based on looking at the firearm, you could see the hammer is back. So I don't think that those specific arguments, they were not the strongest, and the jury rejected them.
So what crossed the line?
I think the stuff about him being a hero, I think that wasn't necessarily supported. But in terms of the arguments around the gun, I would say were within the bounds. They might not have been the strongest argument. They might not have been the most prudent argument, but prudence isn't the test, as long as there was evidence, and there was evidence that he brought a loaded firearm.
What about the statement the defendant didn't shoot for the arm, he didn't shoot for the leg or the foot, he went for the vital organs, he pointed towards the vital organs, and the wound required precision? There was thought in pressing that barrel against Kevin's side, and the defendant's thought was, I want you dead.
Well, he was shot in the vital organs.
Was a shot.
And there was evidence that he attempted to shoot him a second time. So I think.
Was there evidence that he pressed the barrel against his side? I thought actually that it was.
Yes, because it was a close contact.
I thought it was a loose contact, which meant it wasn't pressed against his side.
The medical examiner said it was a contact wound. The ballistician said it was a close contact wound or a loose contact wound, meaning that the full barrel wasn't in contact with the skin, but that it was still part of it, I believe, was pressed or close. And he said that also the clothing can affect how that how the sort of residue is left. But I think it was certainly reasonable to argue, based on the medical examiner's testimony, it was a contact wound. Court has no more questions.
Thank you very much.
Right,
We
thank you.
understand your argument. The case is submitted. We'll take our morning break, and we'll be back in 15 to 20 minutes.
Court is now in recess.
Testing, 1, 2, 3, testing.
All rise. Court is open. Please be seated.
Welcome back. Our rules are still the same, 15 minutes per side, no rebuttal. We ask a lot of questions, so I encourage you to get to the heart of your argument. The next case is 2023 P1155, Town of Kingston versus High Pines Corporation.
Police report. My name is John Fleming, and I represent the defendant High Pines Corporation. Here appealing granting of summary judgment by the court below, and also appealing the nature of the decree or order judgment, whatever you want to call it, that was issued as part of the summary judgment decision. I'm going to give you the very broad outline of the facts in this case because it goes back a long time. But the original subdivision approval, 2000, actually 1998. You know, the first lawsuit filed by the town in 2007, and waited for attorney injunction to help the defendant to finish the work, subdivision improvements. We then have a 7-year period where nothing really happens, and then the town.
Yeah, I had a question on this because there was originally a finding or conclusion from the town that it would cost $64,000 to do certain unfinished work, and then there was a later conclusion that it would cost over $1 million. Were there new items added to that, or was that inflation, or what was that?
I think that this was a mistake by the engineering firm, but they were acting as the agent under the subdivision control laws. Town hires an engineer to come in and function as the town's agent in terms of evaluating how much of the work has been done and whether it's been done in accordance with the plans and specifications. In 2000, the engineer said it's been done. The drainage has been done in accordance with the plans and specifications. In 2007, a different engineer from the same company came in and said, oh, the catch basin hoods, which would cost an additional $350,000, weren't installed.
Can you tell us where in the record the final approval is from the earlier point?
It's in my brief. I mean,
Okay, but is there a document that says this is the final approval? I may have missed it. I just am not looking for some guidance.
It says final approval because of the nature of the security in this case. In this case, the security for performance of the obligations is what they call a covenant. The developer signs a covenant saying that he agrees that none of the lots can be released until the work relating to those lots is done. So in a big subdivision like this, 134 lots, the developer will do, say, 40 lots, and he'll do the roads, he'll do the catch basins, he'll do all the municipal improvements, and when they're done, then the town will say, okay, we'll give you releases for all the lots that abut that portion of the subdivision. But our engineer says we're going to need another $30,000 to finish the work, so you've got to post that bond to get your releases.
Okay.
That's how it works with the developer. So what we're relying on is, and we submitted as part of the record, is a number of reports from the town's engineer, the town's agent, that portions of the work had been done in accordance with the plans and specifications, and apparently he missed the hoods.
So I shouldn't have been looking for a document that says the work is complete at this point, as to this stage, or at any point, basically.
No, there isn't one because
Okay.
the second coat of asphalt has never been done.
But just with respect to the hood issue, the drainage hoods.
Drainage issues is one, I think, that they say 95% of it is
Right.
not, has been completed.
I saw that.
There's 174 catch basins in the subdivision. None of them have hoods.
Okay.
By the time they told us about that, statute of limitations on us going back against the contractor to say, hey, you didn't do the job that we hired you to do was gone. So now the town says it's our responsibility.
Can I focus?
No.
I'm sorry to interrupt you. I apologize. Could I focus back on maybe a more basic question? My understanding is that from your client's perspective, the 2014 agreement is not a contract. Is that correct? An enforceable contract, anyway.
We say that it's too indefinite to be enforced because there are gaps in it. Basically, the agreement says engineers who meet with the parties to confer and to come up supposedly work on the list of work to be done. And then it says what happens in the event that the work doesn't get done. It doesn't say, and this is the problem that has prevailed in this case. It doesn't say, what if they disagree? And it's been apparent since 2007 that there's a primary disagreement over whether the developer has to pay $350,000 to put in catch basin, the catch basin hoods that were made by a subcontractor.
Okay,
And
but
so what is, with this contract, what happens if the engineers disagree as to whether or not they should be installed?
okay, is there a case that, oh, well, let me, before I ask that, the agreement includes a statement that this is a Massachusetts contract, even though that may not be dispositive on whether it is a contract. It includes that language, right? And we're looking, if the argument is that that there's a condition that needs to be met, then we have to find that that was clearly intended by the parties, don't we?
I don't think I can do anything that point to what happens if there's a disagreement with respect to there's no manner of executing or resolving that problem. The attorney for the town will tell you, oh yes, you can imply into the contract that litigation will decide the issue, but that's not what the agreement says.
Well, that may be a fault in the agreement, but is there something more than that that suggests that the parties intended that this first step had to take place and only if something happened, that then additional obligations would follow? I mean, it's logical that you need to know what the work is. I understand that point. But is there something in the contract that suggests the parties were taking it as a conditional step one and then only if that condition is met, moving forward to some further agreement?
There's nothing that addresses that one way or the other. But the primary argument that I would like to make in the first instance is simply the decree. And that's, I mean, this decree basically says this is a contract that's enforceable, and the decree says you have to prepare a list of things, give it to the other side, and let them review it and come up with their response.
I know it's jumping ahead and it's a fairly narrow issue, but one of your arguments is that the judge erred by ordering or by requiring specific performance because it was impracticable for your client to follow through with this, right?
Yes, but
all right. So here's my question. Is there anything in the record, any record evidence that they don't have the financial assets or otherwise are financially incapable of following through?
It's in the judge's decision. IMPOUNDED does not have the money to do the job. We submitted an affidavit.
So where is that? That's, so I see it's in the, is there any, there's an affidavit that says there's no?
There's an affidavit that
Okay.
says that IMPOUNDED does not have the money, and that the court found it, right?
All right, thank you.
Summary judgment motion.
Thank you.
Going back to the decree, I mean, my point would be that Justice Russell would turn me over in his grave, because according to him, going back to 1922, a decree or an order settles the rights of the parties, and it must declare by its own terms what those rights are to the end that they may be enforced. It must inform the parties as to their rights and obligations. And it's got to be in the decree. It can't just be in an opinion for summary judgment. It can't just be a reference to another document. It's got to be right in the decree. And all we have in the decree is that the parties are supposed to prepare these lists and supply it to each other.
Was any issue raised about that to the trial judge, or to the motion judge, rather?
They didn't go back.
But I thought it said it basically said if this doesn't get done by whoever, then the town will do it, and there's only one other party to the agreement. So isn't the necessary implication that it's your client that's doing the doing? I'm taking
But we're supposed to do what's agreed upon.
Right, but it says if the work's not done, then the town will do it. Who else was going to do the work besides you, your client?
But we understood in the first instance that they had to covenant with the town and the obligation to comply with the covenant. But in terms of the settlement agreement, as you just noted, said that if we didn't do the work, they were supposed to take the security and do whatever work they could do with the security and then sue us. They never took the security. They never did any work as called for by the settlement agreement. No one has complied with any of the provisions of the settlement agreement, quite frankly, in my opinion. No stay was filed with the land court. The case in the land court wasn't dismissed for 27 months. I kept going to pretrial proceedings. I had to go to a court-ordered mediation, had to prepare a pretrial memo, all after the case was supposed to be dismissed. And now they say that the provision that you can either pursue the land court case or file a case in state court gave them the option to do both.
Isn't that what or means?
Or,
Yes, the word or. Seems to me means implicit in or is option. You can either do this or you can do that.
you can't do both. It's alternative. It's a conjunction.
Okay. Well, perhaps not both simultaneously. I'm not sure that. Where does it say that? I'm not sure I'm reading it that way, but okay.
Did the, but the,
In some contexts, it can include two things, but in other contexts, when it's used
Right.
as a conjunction, as in this case, it's in the alternative.
Okay.
It's Merriam-Webster dictionary definition.
and
So
your,
anyway,
okay.
This order is just, it's too incomplete to be enforceable. And the town's position again is, oh no, we can figure this out because if there's a dispute as to what the extent of it, we can pursue further litigation. That's not the way it's supposed to work. It's supposed to work that we get a decree. I can tell my client what that decree requires him to do. And I look at that decree and I say, I can't say that that requires you to do the work. It requires you to have your engineer prepare a list, give it to the town, get feedback from the town, and then what?
Yeah, that's the part I don't understand. I mean, that's how development works. The developer does the work. What, I mean, the contract doesn't tell your client to breathe either, but your client knows that they need to do that.
He doesn't know what to do. I just
He's supposed to
that.
finish,
Question, we don't know what that is.
well,
Do we have to install the catch basin hoods? Do we get a chance to object to that requirement? The case law that was submitted to this court all says that if you have a contract that's being done, you've got plans and specifications and an agreement, and the builder does stuff, but it doesn't comply with the plans and whatever, but you say, okay, that's all right. You can't come in after the fact and say you've breached the contract. And that's the garage case. I forget the full citation to it, but it's in the brief. So if I could go just briefly to the waiver argument, because again, this goes back to what I just talked about. If you look at this contract, nobody did what was supposed to be done. There was no stay after the contract was signed. So the land court case remained in litigation. When the work wasn't done in December, the contract says they're supposed to take the security and they're supposed to do the work, and then after they do the work, if there's more work to be done, then they get to sue us. That's what the agreement says. They didn't seize the security. They didn't do any of the work. They just basically sat around for 27 months until we were 6 days before trial in the land, and then say, okay, we're going to dismiss it, and we're going to file a case in Superior Court. Third argument, and it's pretty much the last one, is the question of should specific performance be actually ordered in this case. It's an equitable remedy. It's not a matter of right. It's a matter of discretion. And in this particular case, thanks to the Great Recession and other factors, but the town did absolutely nothing to help in this situation. It's basically a situation where they, out of fear of what might happen, they did things that resulted in it happening. I'm drawing a blank on what the term is. But when they couldn't get the injunctive relief from the land court, they rescinded the subdivision, basically saying you don't have approval anymore. You can't do that without the permission of the bank that is financed. They didn't care. They rescinded it, and they filed a document in the Registry of Deeds.
Can I just clarify, was that well before the 2014 agreement was entered into?
Yeah, that's probably 2000, in the 2008, 2009 timeframe, when they did basically three things.
But can I just ask this, even assuming all of those things are true, and I take your word for what was done, but how does that matter to the specific performance order on an agreement that was entered when there isn't a dispute about whether the facts that you described were known? Nothing was being hidden.
Between 2007 and 2012, there was a big loan on the books. The town did things that prevented the developer, in connection with the recession, from being able to sell a single lot during that 5-year period. You carry that debt, that period of time, and you have penalties and attorney's fees and compounding interest. All those things that they did negatively affected the net worth and created a situation in 2014 where we were dependent upon basically 2 transactions involving, I believe it was 9 lots closing to be able to pay off the bank and probably do most of the work. And those transactions collapsed. And that's all in the record. And I see my light is on, but I just have to comment on this one thing because it really bothers me.
Briefly.
On the summary judgment argument, they say basically that our assertion that the catch basin goods shouldn't be required, shouldn't be raised 17 years after the fact. 2008, the very first pleading in this case that we filed was in opposition to the preliminary injunction. We raised the issue of the catch basins in the prior approval by the town engineers. In the pretrial memorandum that was submitted in the land court case, we raised the issue. In the pretrial memo in the Superior Court case, we raised the issue. We have raised this issue for more than 17 years, and we have a brief here saying that we're not entitled to the catch basin issue is irrelevant because we didn't raise it in the prior 17 years.
Could I ask one question? Sorry to keep you, but can I ask this? With respect to your argument that the town's specific performance request is, if I'm understanding correctly, is foreclosed by the existence and action of Chapter 41, Section 81U, am I understanding that correctly, that you're saying that the town is limited to recovery under the 4 potential security forms that are identified in 81U?
Absolutely, yeah.
Isn't it, just to help me understand this a little bit better, 81U applies when the subdivision permit is being issued, correct?
Correct, and the whole purpose is to establish a security that will be there to make sure that there are funds available to finish the subdivision, because sometimes people don't finish them, and they take off the other cities and they leave the people in the subdivision in a bind.
But it doesn't say, though, that 81U doesn't say that that's the exclusive remedy, does it?
I think the case law says that the provisions of 41U are the exclusive provisions of the subdivision. And I guess I take you back. This has been going on for years.
Can I add one other thing to the equation, just to ask you if you to speak on it? And this isn't something that was briefed, so I understand if it's coming out of left field. But 81Y of the same statute grants additional equitable authority to the land court and superior court to make such decrees as justice and equity may require. Doesn't that suggest that there's a broader spectrum of available relief than just the 4 things that are listed as part of the permitting requirements under the earlier section?
I disagree that that provision there relates to the question of compelling the developer to finish. They may be able to make orders that seek orders from the court that are equitable in terms of how things are going in the subdivision. But in terms of ordering that the developer actually finish the subdivision, Outside daily construction versus planning board of Randolph, it's not in my brief. 340 and 149 talks about how towns and perhaps with the guidance of town council have been taking the subdivision statute and saying that there should be more stuff in it, and that that's not what the legislature intended when it revised the subdivision control laws the last time. This is it. So, thank you for your time.
Thank you. We'll hear from the town.
Thank you, Your Honor. May it please the court, Jason Talon and Town Council for the Town of Kingston. I wanted to start with a quick item here on the law of contracts as it applies to municipalities. Municipalities under Chapter 40 and other authorities have every right to enter into contracts, notwithstanding other remedies that they may have under other various components of municipal laws that applies to land use or any other equitable authorities. This is all well briefed in our pleading. In any event, these two parties, after years of litigation, decided to negotiate a deal to bring this matter to a conclusion, hopefully to bring it to a conclusion. This is not an instance of a town using a heavy weight of municipal law to bring down a hammer on a hapless homeowner. There's 134 luxury homes surrounding a private golf course. For over 20 years, the town has been trying to do one thing, not to gain an advantage in municipal governments. That is seldom the case. They just wanted this developer to finish what they started.
So, but how do we go from, oh, it'll take $64,000 to finish the work to it'll take over $1 million?
Well, inflation does factor into
Yeah,
that.
but even that's a lot of inflation.
The construction costs have ballooned in the last 25 years.
Were any
But-
items added to the to-do list besides that maybe because they left only one coat of paving and that started cracking, but leaving that aside, were items added to the what needs to be done list?
At the time that the town and the developer started to get into this, more precise efforts were engaged in to identify what was in dispute. But here we don't have to guess as to who's right and who's wrong on catch basin roads. That's not required. One of the reasons we structured this agreement the way we did is because we couldn't agree, two lawyers, myself and Mr. Fleming at the time and today, couldn't agree as to exactly what was on the list. We gave them an opportunity, first one in. Hey, come up with a list of what you think is left to do. They've already conceded, as you heard, that the top course of pavement, which is a key item and very expensive, is required. Come up with a list, what else? What else is required? Then our engineer will look at it. Under a contract, as is pointed out by the trial court here, there is a covenant of good faith and fair dealing. If I had my druthers, I would have liked to have listed everything. We had an engineer's report, but they obviously wouldn't have agreed with that. So let's get our professionals together. Step one, come up with a list. The trial court said, yes, come up with a list. Then we'll see where we go. Conjecture as to disagreements is just that. The fact that we may not agree as to what that list is something that could be the subject of future discussion, mediation, litigation, however it may arise. But step one, come up with a list. Now, Justice
Did they ever offer a list?
None. Zero. Did not ever come up with that list for us. All we're asking for is step one. Yes, towns under covenants and bonds do have rights, usually with some other decree of court, to enter onto property and use whatever money is left to do that work. I'll state anecdotally, it's not really relevant for this proceeding. Towns hate doing that. It's a heavy undertaking. It requires an appropriation by town meeting of, in this case, $1 million to do work that a private developer should have, while everyone else in town that would have to pay for that isn't getting the same level of service. In every instance, we exhaust every opportunity to ensure that a developer does their job. That's all we're trying to do here. Now, there is some, it's essentially a litany of Contract 101 arguments here, and we addressed them each in turn, as did the trial court. One in particular that you touched on is, I think, worthy of some discussion, and that is around this item of a barrier to specific performance by a court. The developer has suggested that it is a genuine issue of material fact as to whether or not there is inequitable conduct on the part of the town with respect to, that would preclude the entry of specific performance. It's kind of an unclean hands argument. Here, they have cited multiple pages of what that inequitable conduct was. 90% of it is conduct that happened before the contract was signed. There's no dispute as to those facts, but it doesn't have any relationship. The case law says the inequitable conduct by the town has to have an immediate and necessary relation to the contract. There's no relationship of that to the contract. That's all previous stuff. Everyone went into that contract eyes wide open, entered into that contract. They cite 2 instances of post-contract behavior by the town that forms the basis of a genuine dispute of material fact. First of all, those facts aren't disputed either. And there are 2 particular facts. One, that we exercised our right under a 61A option to buy land not in the subdivision. 2, that we decided not to enter into a contract with them where they might escrow $50,000 for 6 lots, resulting in $300,000.
Wasn't they representing, did the developer not represent that they would escrow that amount of money from those?
They said that they would escrow it, but they were contingent upon
the
sales
sale,
of
right,
those lots.
okay.
Some of those lots may have been undevelopable. I was there at the time. I don't think we have to get into that, because the notion that we could be found to be acting in an inequitable fashion because we choose not to make a business deal with them doesn't form the basis of inequitable conduct. That's just us deciding that we don't want to enter into this side deal with you. As to the 61A right, first of all, the 61A right accrued years and years before any of this happened, and the town has every right to exercise a right under Chapter 61A, which gives them a right of first refusal to buy land not in this subdivision. So there has to be a nexus between that. First of all, we acted within our rights to do both of those actions, refuse to contract with someone that we've had a history of not great conduct with, and to exercise a 61A option. There's no nexus to them doing item 1 under or performing any element of this contract. Those are separate things. The other element of inequity when it comes to a barrier to specific performance is that we have to gain some advantage. If 2 contracting parties have an obligation and one engages in activity in kind of this unclean hands way to gain an advantage, then that could be a barrier to specific performance. We didn't gain any advantage in doing these things. We did things that were good for the town. In some ways, it may have been against our advantage because it didn't help them out in some way, but it didn't help us out to get this work done. There's no advantage that we obtained through exercising our legitimate rights under law to obtain more land outside the subdivision or to choose not to enter into a side deal that we didn't think would get us where we wanted to go on this matter. There's no nexus. There's no inequitable conduct. They spent a lot of time in that. I'm sorry.
What about his argument that the agreement gave you a choice of this or that?
It was just that. as Justice Brennan said, it doesn't say or in the alternative, or shall choose just one.
But there's no and, right, but he's saying you didn't, he's saying you tried to do both, and there's no and or, it's just or.
We didn't enforce the contract initially, and we went back to land court initially to see what that would bear, what fruit that would bear. Ultimately, we determined and dismissed that land court action and availed ourselves of our right to enforce the contract. There's no language in there that suggests that we have to choose one to the exclusion of other and be bound by that decision.
So are you saying you could pursue one for a while and then change course and pursue the other one?
Which is exactly what we did.
Okay.
We dismissed the land court case. There's no dispute on that. Everyone said, hey, you know, we took it as far as we could go here in land court. Let's get that case stipulated for dismissal. And we did. They still didn't perform their rights under their obligations under the settlement agreement. And we sued them.
Could I ask a question that maybe is adjacent to what you're talking about, but a little more basic? It's about the scope of the judgment. I'm struggling a little bit with the fact that my memory of what the town requested as far as relief was summary judgment and an order for specific performance of the contract. Is that fair?
Right.
And it doesn't seem like that's necessarily exactly what the judge gave, and I'm unclear about how to handle the judgment as it stands.
So in a perfect world, we would have had an order from the court to do step one, and when that list is complete, then to do step two, which is to do the work. The judge upheld the contract and sent them on their way to do step one, because without step one, there can't be step two. I suppose they would still be bound by the contract. The judge didn't invalidate any other element of the contract. But we don't get to step two, doing the work, or us exercising our rights to do it ourselves, until we get to step one.
But I'm not misunderstanding that the argument was there is a contract that is step one, and then there is some other separate contract that is steps 2 through 12. It was one document and one agreement has always been the theory.
Correct.
Okay.
We are not operating under any other side agreement or any other understanding. All of the rights. And, you know, anecdotally, because I was there and I negotiated these contracts, would I have liked more precision in this? Again, going back to something I said earlier, I would have loved more precision. I would have loved to attach a detailed list. We disagreed on that list. We gave them an opportunity. Give us a shorter list if you want. Maybe it's only the pavement. Maybe we could live with that and just get you to do the pavement. We have 134 houses that have had crumbling pavement for 20 years.
I'm sorry. Go ahead. So am I understanding it then that, at least as you see it, the judge ordered only step one because she couldn't order specific performance on something that was at that stage still undefined? Is that the gist of it, or you don't know, she just kind of went up to a point and wasn't willing to go further? You really don't know what to read into it?
I wouldn't say that the judge felt that they were unempowered to grant step two. After all, the judge did validate this agreement.
Right.
Did grant a summary judgment that the agreement is valid and rejected all of the contract offenses, one by one, that were raised by the developer. But the judge did only, in the order, say do step one.
Right.
So whether or not this judge, if the judge had felt that step two was beyond the scope of contracting authority, I would think the judge would have said that. I don't think the judge is precluding us from availing ourselves of the rights to enforce under step two or any of the other provisions. But I think the judge felt, and I don't want to put words in their mouth, hey, can we please get to step one here, and let's get a start. Maybe we resolve this long-standing dispute.
One other minor side note, the issue of the Mitchell affidavit, if I have the town administrator's last name correct, there was an affidavit that was challenged by the developer. And my understanding was that the judge essentially found that the affidavit and the information that was attached to it in the form of reports was admissible as a business record. Is there a foundation someplace for that determination of the town administrator's role as the keeper of records?
Well, in municipal law, it can get a little complicated. If I was introducing evidence at a trial and there was a question of authenticity, we might get the town clerk's stamp on it to provide, this is an authentic business record. That might happen for admissibility's sake when you're agreeing to that. Here is attached to an affidavit in support of summary judgment. I don't think there's an argument about authenticity. I think there was an objection on the part of the developer that we included this report, when at the same time, they're referencing a whole bunch of other reports. In any event, it wouldn't, if we were going to mine down deeper into it, this is not a question of we're trying to, prove what's in that report.
Do you need it to prevail on summary judgment? Is there?
We do not. We think it was sufficient to show that there was an amount of work left, and that's what brought us to contract. We're not offering it for the truth of the matter asserted in that, because again, we're giving them an opportunity to come up with their own list. We're not saying that list has to be Stantec. We're just trying to show, hey, the parties were working at this. Can we please get to step one here?
Do you agree that it looks like on the blue brief at page 56, which is in the appendix, at least at some point a judge said it became infeasible for High Pines to comply with the agreement because some closings didn't happen, the money was not generated?
Well, I don't think we have to reach that issue. Knowing a bit about the parties here, having been town council for a long time, I'm not sure. I agree that it's infeasible. I think for the sake of the summary judgment record, it's fine if that's an accepted fact, but it doesn't excuse them from coming up with a list. The infeasibility as to whether or not they can actually do the work would come under later enforcement of the contracted issue here.
All right, thank you. I think we
you very
understand.
much.
You have any other things? You good?
Thank you.
All right, we'll call the next case, which is 2024 P0056, Department of Children and Families versus Father. The case is impounded, so I would encourage you, in fact, we insist that you use pseudonyms. It's just fine to refer to mother, father, and child. I know one of the briefs referred to Mr. and Ms. with initials, and I find that's a recipe for you to say the party's name. So please don't. Just stick with mother, father, and child.
Good day, Your Honors. Jennifer DeFeo. I represent the appellant father in this matter. I will be presenting his Moffett brief to you for your consideration. Father is asking that this court determine that the trial court judge's findings did not establish by clear and convincing evidence that he was unfit. And if he was, there was no evidence to demonstrate that his unfitness was likely to last indefinitely or to a near servitude. He requests that the termination of his parental rights be vacated and that the case be remanded for further review. In furtherance of his Moffett brief, Father states that he was fit at the time of trial and remains fit today to parent child, and that any findings to the contrary are erroneous. Although the judge found that Father did not know what his infant son needed, Father argues that he did indeed know, and he knows what his toddler son will need. Father would ask questions when he had issues as to how to parent the child. He attended the parenting journey class in April of 2022. It is established that a parent may be fit to parent one child and unfit to parent another. In this case, Father is arguing that even if the court found that he was unfit to parent an infant, he is fit to parent a toddler, and the child is now 2 years and 10 months old. So parental unfitness needs to take into consideration the parent's character, temperament, conduct, and capacity to provide for the child with the child's particular needs, affections, and age. This child does not have any special needs. Father maintains that even though the
May
court...
I just stop for a second? When we talk about unfitness, I'm looking at pages 12 and 13 and so on in your brief, where you talk about the father's lifestyle choice and that the judge essentially just didn't approve of the father's lifestyle and his dominant partnership with the mother. Is that right?
Yes.
So the judge characterized it as domestic abuse.
Yes, he did.
All right.
She did.
She did. And I appreciate that it wasn't, in fact, law at that point, and you may not even be familiar because it's pretty new, but the legislature amended the definition of partner or family abuse this summer. It became effective maybe a week or two ago to include coercive control. Coercive control includes, but is not limited to, regulating or monitoring the family, household members' activities, communications, through technological means, and I'm cutting short. So that's the cell phone and the email. Threatening to publish sensitive personal information relating to the family or household member, including sexually explicit images. A single act intended to control a partner that involved publishing or attempting to publish sexually explicit images is abuse, by definition, under our law. So how, and now again, the judge didn't have the law there, but maybe it was just applying what folks generally know to be the case, which is this behavior is abusive and not just lifestyle.
In this factual-based scenario, Your Honor, it is a consensual agreement. So when the woman consents to have certain things happen within the family relationship, which is what father presents, that mother agreed to this lifestyle. She agreed
To the dissemination of the explicit materials if she didn't do certain things that he said or when he was angry at her? Because I'm not sure that that was, certainly the judge didn't find that.
I agree that the judge did not find that. However, father maintains that that was a consensual part of their relationship. And where it is a fact-based scenario, we present that it was consensual and not abusive.
Well, so, but what are the limits to that? Like, if she says you get to make all the decisions, I could see your argument, but if he hits her, then don't we hit a limit on that?
There are consensual relationships in which physical contact...
Let's not, yeah, let's go with he punches her in the face and breaks her nose. Let's go with something extreme. But she said, you can hit me.
If she consents to it, and it is a lifestyle choice, Your Honor, then it is a lifestyle choice which needs to be considered by the judge under Bezio. And that is what father maintains. This was what they chose. He was the dominant partner, she was the submissive. He acknowledges she was weak and compliant. She acknowledges she was weak and he was dominant. This is what they chose. It may not be...
Respectfully, counsel, that's a remarkable proposition, and if you can point to one case anywhere where consenting to being beaten or sexually assaulted or take your pick or abused in some other fashion is then permissible and not a factor in terms of, well, let's just keep it to whether it's a factor in terms of whether someone is qualified to parent.
So, Your Honor, again, this is a Moffett argument that I'm presenting
Okay,
on behalf of father.
Fair enough.
And
Okay.
So his argument is his consensual relationship with the mother does not trickle down to his ability to parent this little boy. So, Your Honor, the other things that he does talk about are his overdoses. He had 2 overdoses. One was 4 years before the birth of the child, and one was in 2022. In the adoption of Elena, 446 Mass. 24, 2006, the court remanded the matter for further proceedings to look at the status of mother's recovery efforts. In this case, father has always acknowledged that he uses drugs, but he did engage in an in-home therapeutic program to address his substance abuse approximately 1 month prior to trial. As such, he believes that this case should be remanded to consider father's recovery efforts. Father states that his upward trajectory since the birth of his son demonstrates that even if he was unfit at the time of trial, he is no longer unfit. And if you have any questions for me, I'm happy to answer them. If not, I would rest on my brief.
Thanks. And I think you clarified that for me, and I appreciate you doing so.
Thank you, Your Honor.
Now I understand that the appellees will be splitting their time 7.5 minutes each.
Thank you. May it please the court, my name is Carol Frizzoli and I represent the Department of Children and Families. Given father's history of aggression, volatile behavior, domestic violence against mother and family members, untreated mental health disorders, and unwillingness to engage in services, that father was unfit, that his unfitness was not temporary, and it was in the best interest of this child to terminate father's parental rights. There was no error.
So just to clarify, so if the mother had said to the father's the head of the family and he gets to make all the decisions, would that be enough to terminate either one of their rights?
Again, in this case, those weren't the facts. There were multiple factors for the right to terminate. But if you're saying that if that was the only factor...
That was the only situation, yeah.
Again, it goes to the parenting ability. You know, what the parents' relationship was, and in this case, it was mirrored with domestic violence while her other children were present. And as you said, you know, sending out videos when and I will say the father in this case testified, he said, or not testified, but he told the workers, well, it's because I was angry at her. That's why I did that. So again, these aren't the facts. This is not a consensual, you know, relationship.
You're saying this is not a condemnation of their lifestyle, of that choice?
Correct. Yeah, the facts of this case are not that description. What father says, again, you know, that he finds her weak and submissive, but his actions and his behaviors were that it wasn't all consensual.
Can I ask you again, when you say it's not a condemnation of their life choices, if in fact their life choices include criminally abusive behavior, then why not?
Again, as Your Honor said, I mean, it's domestic violence. If someone, or assault and battery, if someone hits another person, there is nothing to say that is, whether the woman consents to that.
Another person, apparently that also is something. So again, I guess my question is, and I understand you're kind of walking a fine line, but what's wrong with condemning that sort of behavior if it is, in fact, rises to the level of criminal behavior? I understand it's a small point in all of this, but...
And again, the fact is we have children involved here, and it's, you know, exposure to domestic violence. I mean, there's case law, there's studies done that exposure, even in a young infant age, that's what we're focused on here, is the children and that exposure to domestic violence. So whether, hypothetically, the parents were, you know, consent, again, you're now exposing your children to that. So that's the primary, you know, problem.
How do you differentiate between someone legitimately complaining that the department's in their business and telling them what to do, and what you argue is aggressive behavior toward a worker or a supervisor? Does it, if it doesn't rise to the level of a threat, but if it's like I know certainly the assertion here is that it did, but short of a threat, if they say, well, I don't like what you're telling me about how to parent, and then the report is, well, they're clearly resistant and they're aggressive with me because they're frustrated with how I'm telling them to do things. How do we navigate that?
Well, again, if it doesn't involve the children, I mean, again, these cases, we have to have nexus. I mean, if, you know, a couple has, you know, arguments and children aren't involved, then, again, that's not what this case or what our case law supports. But in this case particularly, it was the acknowledgement of, you know, his aggressive behavior was demonstrated even in, for example, he had proposed his sister as a placement for this child. And he ended up kicking her downstairs, and she ended up getting a restraining order and withdrew her wanting to be this child's guardian based on that, because she didn't want to be involved anymore with her brother. So again, it's how it affects the children. That's what we all come down to in this case. So it's the department's position that the trial court properly found by clear and convincing evidence, all of which was unchallenged, that father is unfit to parent this child. This unfitness is likely to continue due to, one, the history of violence that we just talked about towards his family, his violence towards mother, including altercations when mother was pregnant and in front of other children, of her other children, his ongoing and unaddressed substance abuse issues, his refusal to treat his mental health struggles, including bipolar disorder, OCD, and anxiety, and his refusal to engage in any services which might address these issues, and finally, his demonstrated ability to care for this child during supervised visits or to provide the child in a safe and stable environment. So it is the department's position that this case should be affirmed, and that father's actions, again, by not engaging in any services, and his violence just poses such a substantial risk to this child, we would request that the decision be affirmed. So if there are no further questions, I would rest on my brief.
Thank you. We'll hear from counsel for the child, and just for the record, I'm freezing, so I'm listening to you in a very closed position, but I am listening and open to everybody's arguments.
Good afternoon, Your Honors. May it please the Court, my name is Julia Healy, and I represent the appellee child in this matter. The Court did not err in terminating father's parental rights or in approving the plan of adoption with the child's current pre-adoptive parents. The Court's non-challenged findings, the Court made 161 findings of facts, father challenged none of them. The Court's non-challenged findings showed father's current unfitness by clear and convincing evidence. The Court correctly found that father was controlling and emotionally abusive toward mother and lived in a situation of domestic violence. The father also had violent and threatening behavior toward DCF and toward his own family. My sister has covered a lot of this, so I'm happy to go into more particulars if Your Honors would like. Our case law is clear, adoption of Jacob in particular, Vaughn, Lilith, that the Court can and should consider manic, controlling, threatening, unpredictable behavior, violence of temper, and inability to control parental conduct, which is what father showed in his actions toward both mother and his own other family. The Court also correctly found that the father's inability to control his parental behavior toward the child during visits was evidence of his unfitness. The Court also found that father's unabated substance use was a risk to the child's safety and related to his ability to care for the child, as well as his pretty almost complete refusal to obtain services. I believe he did complete one parenting course, and he said a month before trial that he was involved with a substance use specialist, but there was no evidence of that. Other than that, he, I believe, did nothing on his service plan. Beyond finding father currently unfit, the Court also correctly found that father's history of refusing treatment for substance use, domestic violence, and anger issues were likely to persist into the indefinite future, and that termination of his parental rights were in the child's best interests. And finally, the Court properly decided that adoption by the child's pre-adoptive parents were in the child's best interests, and I will go into that for a moment. The child was 17 months old at trial. He had lived in his pre-adoptive home with his two siblings for half of his life. The Court correctly considered DCF's plan of adoption and the strong positive bond the child has with his pre-adoptive parents and his siblings, and that removal from their home would cause him serious psychological harm. The Court considered that the family provided the child with a safe and stable environment, cared for all of his needs, and that the baby was very happy and easygoing at trial. And if there are no questions, I will rest on my brief. Thank you.
Thank you very much.
Attorney DeFeo, just again, sorry. It took me more than it should have. The moment was longer than for me to appreciate the context of what you argued.
Thank you, Your Honor. We'll call our last case today, 2024-P-0123, East Longmeadow Redevelopers, LLC versus Town of East Longmeadow. I know I believe we have Attorney Pill here, and then I think nobody else filed a brief, but you're permitted to be here and answer questions.
Correct, Your Honor. Attorney Jesse Belcher-Timmy for the town of East Longmeadow.
Thank you. So we'll hear first from Attorney Pill.
Thank you, Your Honor. As Your Honor said, Michael Pill for the defendant, intervener, appellant, East Longmeadow redevelopers. And just adding to what the court said about Town Council Belcher-Timmy, he having made the trek all the way from Western Mass down here, I and my client certainly have no objection to him speaking in any manner the court would allow or answering any questions the court may have. It's about a 4 or 5 hour round trip.
Yes, I know, thank you. I am in the minority here. I wish we would allow more people to appear by Zoom, but the general policy is that people come. So.
Thank you, Your Honor. And there being no opposing briefs, I think in the interest of time for everyone, if the court has questions or concerns?
Yes. So, normally we confine ourselves to the record, but this case screams of the question of mootness, even without whatever filing occurred that you were unhappy about. So what is the status of the litigation between Longmeadow redevelopers and the town of Longmeadow, and what's the intervener's current
Your Honor,
involvement or not?
I brought with me, and the court, I believe, could take judicial notice, and if the court wishes, we could electronically file our motion to intervene in the Chapter 240, Section 14A claim in the second amended complaint by East Longmeadow, and also the memorandum of law in support of that motion, which frankly is in significant part copied verbatim from the appellate brief in this case.
Right, so one of the questions I had was, is there a more robust factual showing in this later motion? Because it seems to me you get one bite at the apple, so I was wondering which bite you want.
I think, Your Honor, certainly there are facts in that later motion, but I don't think any of them go to the three issues that I've raised on appeal, I think, which are pretty solidly questions of law. The history with respect to 240-14A, how the land court has handled that hasn't changed. And also the next two issues, the application of Rule 24A and the intervention, my argument that the intervention should be allowed because the interests aren't identical, that's virtually verbatim. And while it's not in the record, I believe it would be appropriate for the court to take judicial notice. That's Land Court 2023 Miscellaneous 000336, also captioned East Longmeadow Redevelopers, LLC versus Town of East Longmeadow Planning Board, and the Fields at Chestnut Condominium Trust Defendant Intervener. And our motion and the memorandum of law are both dated April 11th, 2024. And so the court could certainly see for itself. And I don't think there's anything wrong with copying one's own work. So I thought about that and looked into it and concluded it's not plagiarism if I wrote it myself. Thank you.
So how do your clients' interests deviate from the town? Or is it just that the town, you think, doesn't have enough money?
I think, Your Honor, and as I addressed in my brief, I think there's a fundamental inconsistency in interest. As I explained, the town's role is to exercise the police power for the public health, safety, and welfare, and that's what Euclidean zoning is all about. Our interest, 116-unit condominium, each, and they're separate single-family homes, each one worth upwards of $1 million. Our interest is, quite frankly, the adverse impact both on traffic. I note that our only access is right next to the driveway for this proposed 500,000 square foot, 12-acre industrial development. And the zoning bylaw, I believe, also allows us to raise value. And I think private property interest versus the public interest, and also in the cases I cited, the Massachusetts federal cases where they've acknowledged that there have been instances where, say, a municipality concludes they want to settle the case. And I think, on the one hand, and
Can I ask you, it seemed remarkable to me that there's no Massachusetts case law on this, or is that, in your view, a function of what you say earlier, is just that the land court usually just lets, sorry,
my apology, Your Honor,
I
I'm an
talk
old geezer.
fast, so let me slow it down. I said I find it remarkable that there is no Massachusetts law on this, or is it just because, as you say, the land court usually lets folks intervene?
I've been litigating in the land court since the early 1990s, and again, while it's not in the record, I could certainly supplement the record with an affidavit. Historically, the land court, as the cases I was able to find indicate, has had a completely open door. I don't know how many times I remember publishing the newspaper ads and being very carefully told by the recorder, the clerk, wait to see who else shows up before we go through. I think that's the reason there's no case law on this, and they've stopped somewhere along the line. I don't recall where it was.
But the judge here says, well, this isn't a question of publication because you know. You didn't need to be reached by publication, and that there's a standard and you don't meet the standard.
I'm only referring to the publication to answer His Honor's question about why I think there's no case law, and also to show that the land court I think has adopted a very open-door attitude in terms of how Rule 24 should be applied just to this particular type of case. And indeed, I think that's a limiting factor here. All we're saying is that a broad interpretation of Rule 24, we're only asking that it be applied here to 240-14A actions, whereas I note they're a little unusual in American law. No case or controversy, no exhaustion of administrative remedies, and this court having stated in a published decision, Hansen and Donahue, that standing is something of a misnomer here.
Right, but so you were not aggrieved in the sense that the town denied the permit, right? You're not aggrieved because the town denied the permit, right?
That's correct, but and what I'd respectfully submit is that harkens over to the 40A-17 cases where aggrievement is a whole different situation, which indeed the legislature has just made even a higher bar with its amendments requiring pleading, adding pleading requirements to Chapter 40A, Section 17. And so part of my response would be, it's not clear how much agreement, other than a general assertion of an adverse impact on neighboring property, is required, the divergence of interest, and I believe I also at least made as much reference as I thought I could based on the record to the difference, the limited resources, noting that the town did adopt our motion to dismiss, which suggests that, you know, a municipality with so many claims on the taxpayers' funds, in this case, I think showed by that action that it could use our support.
Could I ask this, with respect, I understand, I think, your argument with respect to aggrievement under Section 17, but given that this is a claim, your only request to intervene is under 240-14A, asking for essentially an interpretation of the bylaw. Is that?
Exactly correct, Your Honor, and I believe that's why, if this were a 40A-17 action, we'd have a much higher hill to climb. I think that's a whole different situation.
I think I understand that argument. What I'm having more trouble understanding is why, if what you're looking for is an interpretation of the bylaw, why your client's interests and the town's interests are not congruent. That seems to me like it doesn't matter whose private property interests prevail, you're looking for the same thing, for this, which is an explanation of what does this bylaw say.
Oh, and the reason that's absolutely crucial is, and I believe it is in the trial court record, if not in the record appendix, is that East Longmeadow Redevelopers claims this 12-acre building with 100 loading docks is a warehouse, primarily something for storage rather than, say, an internet-style dissemination of goods to retailers. Also, the bylaw refers to wholesale. And if all they can use it for is primarily storage, which can be argued, but for only distribution to retail stores, not direct distribution to customers, that pulls the rug out from their entire argument that this is site plan review, which could not be denied because it's a matter of right. And so this legal issue is absolutely fundamental. If their interpretation of the bylaw is correct, they've got site plan review, and then we in the town would have to fall back on, are there really intractable problems, which would be another potential appellate first impression case for site plan review, use by right that can be conditioned, but very limited denial, or if it's not a wholesale warehouse, then it's not a use by right, and they, I think, would either have to apply for a discretionary special permit, which would put the town in a much better position to deny it, or it may not be allowed at all.
But maybe I'm missing the point. Maybe not understanding all of the points you've raised, but accepting the points that you've raised. I don't understand where the town's interest and yours are, where the town is not adequately representing your client's position on those issues, because at least as things stand now, it looks to me like the argument that's being made is not, although I'm not suggesting you've waived anything, but the argument seems to be whether the bylaw permits the town to deny or revoke an as-of-right use based on a failure of reasonable conditions. Is that correct?
If there are, yes, and the response to that, and I think it is mentioned in the brief, we had to hire the experts, the traffic expert, for example, to show the intractable condition. I mean, that cost tens of thousands. I'm not sure the town had those resources. And also, again, I'm getting into things that I think are in the trial court record, but they are there, I believe. In other words, there's two key intersections that would need to be rebuilt for the truck traffic for the distribution facility. If the developer says we'll pay to rebuild those, the town may say, okay, if you'll solve all the resulting street problems that we consider intractable, then we'll settle with you. We still, as a matter of property, and having those hundreds of trucks right in front of our driveway, and this kind of industrial development next to upwards of $1 million homes, as a matter of property and private interest, we wouldn't want it there. That's where I think, as I noted in the cases I cite, the interest of the municipality. There are situations where the municipality is willing to settle with the developer, where a private abutter would not be, and I hope I've answered Your Honor's question.
I think you have. So the fact that your client could come back at a later time, if in fact that happened, and bring the same claim, that you could bring a claim asking for interpretation if the town settled its claim now, in your view, is not sufficient. The fact that there's another alternative doesn't mean that there's a basis for denying your right to intervene.
Yes, it makes more sense in terms of not just judicial economy, but economy for everybody, for us to have a seat at the table. And the developer is not here, but speaking from my own experience, I can't imagine they want to have an endless stream of lawsuits.
But the way it works would be if the town settled, then you would either try to intervene again, or you would, if they get their permit, you would then challenge the permit, right?
If we had notice, yeah, which we wouldn't be entitled to necessarily if there was, say, a settlement. And that's one of the situations that
But I thought even if there was a settlement, once the permit issues, don't you have another chance to try to do something to fight the permit?
The reason I'm smiling, Your Honor, is that's what Land Court Judge Foster has called the ghost hunting land use law, where they would have to, and that's part of the battle why the town joined in our motion to dismiss the 40A17. For site plan review, they're supposed to apply for a building permit, and that's supposed to be denied. Then they have to go to the zoning board and be denied there, and that's so they can get into the 40A17 framework with exhaustion of administrative remedies. And so again, I would respectfully submit it would make more sense from everyone's perspective, including the demands on the court, for us to be able to participate now and hopefully settle some of these issues, especially the key interpretation of the zoning bylaw issue at this time, which I think could end up resolving the whole case depending on how it goes.
Right. Like you cited the Barcan case, which I have to say I was on that panel, but not the author. And, but even here in that case, we say, had the plaintiff sought to intervene at the commencement of that litigation, they may well not have been allowed to do so, given that the town was defending a zoning order that benefited them. And I'm trying to understand why this case, isn't that what we have here? The town is defending an order that benefited you.
I'm sorry, the town, again,
is defending an order or lack of order that's benefiting your client.
Yes, but the defense then becomes a matter of it may benefit our clients, and if we were under 40A17, that may well knock out any claim of standing we could have. But under 240-14A, where we have the narrow issue of law, I would respectfully submit that it's distinct from that kind of situation where it benefits our clients. We're not here adjudicating the permit. In fact, there's 240-14A case law says you can't use that to appeal what amounts to a zoning permit. Here, we're focused on, is this a use as a matter of right or isn't it? And that's a 240-14A question of law, which I don't think reaches the issue of whether or not we're benefited by a permit denial or not.
But is the town arguing for the same interpretation of the bylaw that you're arguing for?
I think I have to...
He is going to get a chance to speak, I can assure you of that.
Since I don't want to speak for town council, I would say I would hope...
Well, from where you are, from what you know, do you think at the moment you're on the same page with the town?
I'm not sure they've really focused on the question of law, the 240-14A. They adopted our motion to dismiss the 40A-17 appeal because they tried to go directly from planning board denial of site plan review to the court instead of the exhaustion of administrative remedies with building permit and zoning board. So I don't think, I'm not saying there's an overt disagreement, but I don't think the town has focused on that key issue about wholesale trade and operations warehouse.
All right. No. All right, I think we will hear, at least I have a question for the town attorney, so.
Thank you, Your Honors.
Good afternoon. Attorney Jesse Belcher-Timmy for the municipal defendants.
Sure. So we've got significant case law that says that the question is, are your ultimate objectives in the litigation, are you protecting, are they the same, so that you're protecting essentially his client's interests? So what's your position on that?
So, and I'm going to try to thread a line here because we took no position on the motion and filed no brief here. And partially that's, I would say, because they're not necessarily 100% on the same page, necessarily, depending on how this proceeds. So to Attorney Pill's point, I don't think we've gotten to the point on the 240-14A where we've gotten into the nuance of interpreting the bylaws at this point.
I'm sorry, could you repeat that? You don't think you have?
We haven't, this has gone up and down several times, remanded and come back, and there's still a pending motion to dismiss on the new 40A-17 claim, which has been the focus of our fight at the moment, the procedural aspect. Attorney Pill referenced that whether it should be before the land court yet or not. We haven't gotten into the interpretation of the bylaw itself on a sort of substantive level yet. I would say that not in the record, but sort of the proceedings that have happened at the board level and intermittently, the town and Attorney Pill's clients have not always been on the same page as far as what the concerns might be and what solutions might be palatable depending on various proposals or modifications to the plan.
So is he correct, though, that their interests might be a little different because they're interested, say, for example, in not a lot of traffic and not a lot of noise, and your interests might not be the same as that?
I can
Like, I
see,
would think the town might be interested in some revenue, for example.
and it's always hard to speak for a town, right?
Yes.
But I can see a scenario where my instructions or my client's goals might diverge from Attorney Pill's client's goals.
So I am not an expert in this area, but it seems like our case law sort of creates a little bit of a bind for clients like Mr. Pills, where we say, oh, you can't intervene, and you don't seem to have a right to know when the town might be trying to settle, but in this somehow moment of time, you can somehow do something. Am I missing something here?
In the sense that it puts people in a bind, I think you're exactly on point. I've represented clients in similar situations, and it can be hard to determine when to intervene, how to intervene, and what your role will be in a 240-14A situation.
Well, so, I mean, should the order be you can't intervene, but everybody's got to tell you when there might be some settlement discussions?
I think essentially you could have a scenario where you're ordering Attorney Pill's clients to be involved in settlement discussions. I mean, I would hate a situation where I negotiate with East Longmeadow redevelopers and we reach a resolution and then we're ordered to submit that to Attorney Pill's client for approval or intervention. At that point, I mean, there's been extensive discussions and a lot of work put into these settlement talks that have so far not been fruitful. So I'm not sure that it would be efficient to do anything along those lines.
But if we don't do that and you settle, then what's the opportunity for, and assuming your interests have diverged, in fact, then what remedy does his client have?
So if I can just answer that in a hypothetical world as opposed to with these specific clients, I can see, I believe that scenario you've just described is less efficient even than the inefficient scenario of allowing them to review or get involved in while we're in the midst of settlement talks as opposed to being involved. I don't think there's a whole lot of extra work or inefficiencies in allowing an intervener in a 240-14A from the outset, and then they would be a necessary party for any settlement discussions.
So he's maintaining that there's an issue here of first impression. I'm going to have to find it, but you might actually be able to just state it. Do you agree with him that is an issue of first impression?
On the issue of intervention of a,
Yes.
240-14A?
Yes.
So again, I didn't do a brief and I did not do a whole lot of research on this. I'm not aware of any appellate case law on this specific issue.
Okay, all right. All right, thank you very much. I appreciate you making the long journey. We understand your positions are non-positions, and the case is submitted. That concludes our sitting today. I want to thank our staff and court officers for their assistance, and we're adjourned.
All right, please.